नहीं लिख दो. This is the first extension.
तुम दे द मेमो फेर दे
दे दिस लिखी जाए.
इलेक्शन तो सरला को एते कथा कोन
आउडे एंटीसिपेटेबल
आ गोटे दीटा हबनी जणे कर दीटा हबनी का
Supplementary list item number 1, submission.
My lord, this is regarding transfer of the 125 proceeding from the family court Bhadrak to family court Jaspur, my lord.
125 proceeding from family court
Bhadrak to family court Jaspur, because
how far is it from Bhadrak to
both are residing at Jaspur. Both are, so it will be convenient for both the parties.
no
Both the
No,
parties.
no.
But Bhadrak has no jurisdiction, my lord.
yes you raise that point
And
you raise that point
another fact is, my lord, I have also filed a petition, section 9 petition at family court Jaspur, my lord.
No.
And I am trying to solve the matter amicably
No.
in that case.
no
If
No.
considering
Considering no, sorry.
If notice will be issued.
no I will not issue notice
She will
no
agree,
sir I will not issue notice considering the
agree,
grounds
my lord.
raised
She will agree, my lord.
this court is not inclined to entertain the application for transfer. Stop. The application for transfer is therefore dismissed. It shall be open to the petitioner to move the court below, seeking permission to appear through virtual mode if he so desires. Yes.
Item number 2.
The transfer of GR case, my lord, from Hon'Ble to Niagara
Why?
or any other court.
You are the accused.
I am the accused. I am father-in-law, mother-in-law, and the husband.
Yes.
So the father and the mother-in-law is concerned, my lord. They are the old persons. Fact remains, my lord. Now the charge has been framed. Before
Yes.
that, in 2-3 days, my lord, on their appearance, they have been threatened. And that is the reason behind I could not able to attend in the court, my lord, because of that.
Move the court below.
And
Move the court seeking permission. Therefore, transfer of GR case number 656 of 2019, pending in the court of Learned JMFC Barampur to the court of Learned SDJM Nayagarh has been made on the ground that the petitioners apprehend danger to their life at Barampur.
1 and 2 are the old persons also, 76, 70.
Further, the petitioner numbers 1 and 2 are also elderly persons, for which it will be inconvenient for them to appear on the dates of posting of the case at Barampur. Stop. Considering the grounds so raised, this court is not inclined to accept the same. Firstly, for the reason that it is always open to the petitioners to move the court below, seeking necessary orders if they are threatened by any person. And secondly, they can also seek permission of the court to appear through virtual mode. Stop. In such view of the matter, the transfer application is dismissed with liberty to the petitioners to move the court below. Move the court below as stated above.
Dispose of it. Better come.
You are a new practitioner, Mr. Tripathi. Is it dismissal of
Item number 3.
Item 3. Yes, pass over. Item 4.
4.
No, please, madam. No, so not filed 125 CRPC before Judge Family Court to Khurda. Thereafter, my lord, the husband of the petitioner filed divorce petition before the family judge Bhubaneswar. So I pray, my lord, that.
Well, issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed by Monday peremptorily. Place this matter on
12th July.
12 July. IA. In the meantime, if any application for adjournment is moved by the petitioner in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case.
Item number 5.
My lord, this transfer petition has been filed by the petitioner as a wife, and she has filed to transfer the divorce petition filed by the husband from Bhubaneswar to Cuttack. The reason behind, my lord, the case is of 2021. She had continued to be there. But right now, at the moment, no male person is available to take her to Bhubaneswar, and she is totally dependent upon someone as a sole noble person to take her to the Bhubaneswar court and assist. Father was there. He was a fisherman. He used to assist. 3 months back, he expired. Man. So there is no question of chance of for her to attend the court. And apart from this, financially, there is no assistance from the husband. No petition of any interim maintenance has been granted, either from the court of Cuttack on the case which has been filed in the maintenance case by the wife, by the petitioner. Even in the divorce petition, she has filed under section 24, but nothing has been done, my lord. Still, the case is pending for conciliation, and the case is being and the tactics has been made by the opposite party to just linger the matter.
Not inclined.
And my
Not
lord,
inclined. The petitioner seeks transfer of CP number 481 of 2021, pending in the Court of Learned Judge Family Court to Bhubaneswar, to the Court of Learned Judge Family Court at Cuttack. Stop. The petitioner is the wife. Stop. The case in question has been filed by her husband way back in the year 2021. Stop. It is submitted that there is no male person available in the family to accompany the petitioner to Cuttack, to Bhubaneswar on the date of posting of the case. So, further, she is also financially weak. Stop. Considering the grounds so raised, this court is not inclined to accept the same as a valid reason for transfer of the case. Continue. More so, as the petitioner can always appear through virtual mode and also take the assistance of the legal services authority in case she is hard pressed, in case she has no means to engage a lawyer. The transfer application is therefore dismissed.
my lord, there is no question of this virtual mode in Bhubaneswar. This is the problem.
There. Yes.
Item number 6.
No, item number 6, Mr. Pradhan has requested me to pray for a Passover after lunch.
After recess. All right. That's all.
Item number 7.
May it please you, Lordship. But the husband filed the petition under section 9 in the district of Noyagarh. But he seeks the wife appeared and she seeks transfer to SDGM Bhanjanagar, my lord. Your Lordship may permit me to make a correction in the prayer portion, my lord. There is a mistake, my lord. From the Judge Family Court Bhanjanagar to the Court of Learned Civil Judge Senior Division Bhanjanagar. It's an inadvertent mistake, my lord.
All right. Learned counsel for the petitioner is permitted to correct the
Just
typographical error in the prayer portion of the application in court. Yes. On what ground are you
there is 85 kilometers distance, my lord.
from Nayagarh to Bhanjanagar?
Yes, ma'am.
All right. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by Monday peremptorily. List this matter on 12 July.
Oh, best. There's
There's an IA.
I beg apology.
In the meantime, it shall be open to the petitioner to seek a adjournment in the court below. And if such motion is made, the court below shall consider the same having regard to the date fixed for hearing of this case.
Item number 8.
Great teacher hospital. Hereby the petition for marriage is the wife and opposite party the husband married. Husband filed a case ballot under section 9 of the Restitution 9 of Hindu Marriage Act, and under section 10 also. Two cases have been filed by the husband in the court of Judge Family Court, Baripada, my lord. My lord, challenging the same, my lord, I filed a TR CP, my lord, on TR, my lord, on which was registered as TRC number 152 of 2022.
Yes.
My lord, there, my lord, notice was issued to the husband. Husband appeared and filed an application that he wants to withdraw. He has already withdrawn both the cases before the Judge Family Court. My lord, may kindly see Annexure 4.
Yes.
The order was passed in that light by this Honorable Court.
Has been withdrawn on 26/9/2022.
My lord.
Yes.
My lord, he has already withdrawn, and accordingly, my lord, when the case was taken up on 30th September here, my lord, he submitted in that counsel appearing for the husband, submitted in that line, and accordingly order was passed. My lord, after that, my lord, again he filed an application before the Judge Family Court under section 30.
So this is in 2021. That was now it is in 2024. He has filed another.
My lord, my lord.
How it is maintainable? 23 Order 23 Rule 1.
Yes, my lord. That the my lord may kindly see Annexure 4 and 5.
Tolerate. We'll take notice. Take
My
notice.
lord.
Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by Monday. Peremptorily list this matter on 12 July. In the meantime, if we'll state. In the meantime, there shall be stay of further proceedings in CP number 63 of 2024, pending in the Court of Learned Judge, Family Court, Baripada, till the next date.
Item number 9.
In this case, as per the civil proceeding number 174 of 24 from Learned Judge Family Court to Learned Judge Raurkela. I am the
Learned Judge, Family Court, court together.
Learned Judge from Kotak.
From Kotak to Raurkela.
To Raurkela.
You are residing at Raurkela.
Yes, I'm wife of the petitioner.
All right.
A wife of the opposite party.
All right, take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by Monday. Peremptorily list this matter on 12 July.
Item number 10.
So kindly taken up the matter after 1 week.
List this matter 1 week after as paid for.
Item number 11.
Yeah, please. In this case, covered by Dhananjay Chana Demail.
Yesterday you said, but you did not. I had passed an order where I had said that it should be through individual representations.
I'll give number.
See, order आपने दी थी?
Mile.
See, order आपने रोनांग को दी थी तो? Individual representations.
Today I have that order.
Today is also melodic, it is related to.
So it has to be individual representations.
Yes, madam. Today I have already given the number.
नहीं same answer कर दो हाँ? रोनांग को कर दो उसे बात करें
This is the individual representation order.
No, I am not individual. I mean, the individual representation.
This is the order.
देखिए.
Sorry. This is.
No.
Kannai Charan 9 and others.
Yes.
Dated 8/5/2020.
हाँ. ये जो पैराग्राफ तो 5 है इसी से आंसर हम लोग है ना? हाँ. एक तो मुझे दे. Yes.
Item number 12.
Item 12 mail same mail.
Item 12 is same.
Same
Yes.
mail.
All right.
Item number 13.
13 also different. This is the challenge the rejection order under Annex 8 mail.
Just go.
Your also can see page.
What is your prayer?
Delete
The
the
monthly remuneration 30/6/2006 the period is worked as education volunteer and email website as Gana Shiksha. आप तो Gana Shiksha भी ना थे.
No.
चले.
Yes, it petition was pursued since 2009 mail. 3 successive order passed by this honorable court mail. 3 rejection order similar grounds has been passed.
Let us see what is the fact.
Mail.
You were working as education volunteer.
Volunteer mail in 2006 mail under Annex 1 mail. But you kindly see page 21 mail.
Yes.
Thereafter mail, after joining the same day, 36/2006 mail. Thereafter mail, his subsequently his salary mail is 1,000 per month mail. Thereafter enhance is 1,700 mail. Till his post 31/3/2008 till his area salary not been released, my lord. Thereafter, petitioner made a representation before the authorities, my lord. There are
No, area salary, that enhanced part.
my lord. Enhance also as well as 1,000 per month salary, my lord.
Hmm.
Thereafter, my lord, petitioner made a representation before the authorities, my lord. Thereafter, not consider petitioner filed a petition before this honorable court, my lord. This honorable court passed an order. You will see kindly see page 4.
Page?
Page 4 in the petition, my lord.
Hmm.
11 page 5, my lord, para 4. Considering the right of the returns education volunteer, this court disposed of the petition directing opposite part number 1 to cause an inquiry, and if satisfied that the petitioner had discharged his duties for the period from 2006 to 31/3/2008 and his area have not been paid, pass appropriate orders for disbursement of the same as expeditiously as possible, prepared within period of 3 months. Thereafter, my lord, that has not been paid, thereafter petition file a contempt petition, my lord. After contempt petition filed, the collector cum chief executive Kandhamal rejected the claim of the petitioner, my lord, under Annex 2, my lord. Page 26, my lord. In this case, my lord, as you can see,
He says that it was closed with effect from 1/10/2005.
my lord, that there has not been closed, my lord. See, only for thereafter petitioner filed another petition, my lord. Another petition in this order challenging this rejection order petition challenge before this honorable court in challenging the writ petition WPC number 6785/2009, my lord. This honorable court directed, you also kindly see that order has been quoted page 8. This honorable court directed, my lord, releasing the salary, my lord. University page 9. It is made clear that the collector Kandhamal came to conclude that school is question has been closed, wanted to that, but there is no requirement to pass fresh order. The collector is expected to look into the matter regarding communication out of bar 2006 passing speaking order, madam. Thereafter, this order has been passed. Thereafter, for again rejected, madam. You also can see page Annex 6. Same ground, madam. This EJ center has been closed.
No, unless you say that this finding is perverse,
My lord.
this is a purely factual aspect. Why should the court interfere? When the collector finds that the school was closed with effect from 1/12/2005,
Right.
even after verification of the documents on the direction of this court.
It's only verification that the then Sarpanch has been, you also can see this present rejection order Annex 8.
Hold on.
Page 40, madam.
Yes.
Last part, madam. Whereas it is clearly revealed that inquiry report of VRCC, the mode one submitted by letter number so and so, along with the statement of Sarpanch Japan and statement of villager Gundavaru, statement of CRCC. The petitioner Jyotirmay Sarang was not working as education volunteer in Gundavaru Education Center, and the related paper submitted by Sarang in the support his existence to work as EV education volunteer in Gundavaru Education Center concerned are totally false and fabricated one. Thereafter, my lord, page 41, my lord. Whereas it is also revealed that the statement of the Sarpanch Jirkani that the petitioner Jyotirmay Sarang had not worked for a single day as education volunteer in Gundavaru Education Center did not give midday meal to the students. Petitioner Sarangi had managed to obtain the signature of Sarpanch concerned, assuring the letter to work as EV in the Gundavaru Education Center. To that effect, my lord, the then Sarpanch has filed and sold an affidavit that the Education Center has been continued. You will also kindly see Annex 9 series. To Sarpanch, my lord.
Why did he file this affidavit? What was the necessity of filing this affidavit?
That only Sarpanch affidavit was shown that the collector has rejected the case, my lord.
No, this is a purely factual aspect. The collector has considered the matter thrice and he has been satisfied.
Same ground.
Maybe self-same ground. Because this court directed that if the collector is satisfied that the EJ center had closed, then no further order needs to be passed. That is what the
Once again, another inquiry was conducted by the
collector.
no BDO.
Yeah.
BDO was
BEO. BEO, Tumbudipan BEO. And that was in the year 2018. Taking into consideration all these aspects, once again, it revealed that, my lord, no such EGS center was there and the petitioner had never worked. And that is the reason, my lord, they reached to such a conclusion. And that was passed on 1/10/2022, which has been challenged now.
communicated letter.
Maybe.
That EG centers continue, my lord. To that effect, only one
You are relying upon an affidavit, which is a self-serving affidavit.
No, and another is annex 4, my lord.
Yes.
Page, my lord, 31. It is, my lord, it is evident that EGS Center Gundabaru, which is present continuing, my lord, is able to entry register of the endorsement of the signature of CRCC, dated 31 page 31, last one, my lord. CRCC has been signed. Full name is, my lord, page 33. EGS enrollment figure in Jirpani cluster for the year 2017-18. Serial number 9, my lord, Gundabaru. EGS Center is continuing, my lord.
I have my doubts. Let us see the order of the collector.
Did you only say that, my lord?
A closure report was also submitted. The closure report was also submitted.
Please,
See, only suspension in the
second para.
rejection order, madam, my lord.
Where is that inquiry report of the, do you have the block execution officer's inquiry report?
No, see, that I'm
I do not.
Clearly visualizing the petition was never engaged as a but the petition managed to obtain signature of So unless you show prima facie even that this finding is perverse, this court will not interfere.
Thereafter only it only made that the Sarpanch, Jirpani statement, villagers statement, CRCs was against the petition is not correct.
How?
Then Sarpanch also given and so on.
So that is what, why will the Sarpanch give an affidavit? It is a self-serving affidavit document.
The
It is
petition,
not, it is not a document which was there in existence prior to the dispute arose.
the petitioner produced that affidavit before the collector, my lord.
Who is he to produce that, and what is the value of that affidavit?
Your lordship passed an order.
No, Avani, sorry. The petitioner has approached this court. I am dismissing your application.
And thou next to.
No. The petitioner is, how next week you have,
Now the document you received for.
किसी document, excellent, excellent. The petitioner has approached this court seeking the following relief. The case of the petitioner, I briefly stated, is that the petitioner claims to have been engaged as an education volunteer under the EGS in the Gundabaru EGS Center of Jiripani GP under Tumudi Bandha block of Kandhamal district in the year 2006. Initially, the monthly remuneration was rupees 1,000 per month, 1,000, which was enhanced to rupees 1,700. The petitioner claims that the enhanced remuneration for the period from 30/6/2006 to 31/3/2008 was not paid to him. He approached this court in WPC number 6785 of 2009, challenging the non-release of his arrears salary. This court directed the collector, Kandhamal, to consider his grievance as contained in a representation. The collector had order dated 3/5/2010 rejected the claim of the petitioner on the ground that the EGS center in question had been closed as on 1/10/2005 and was never reopened. Stop. The petitioner challenged said order of the collector before this court again in WPC number 16122 of 2010. This court by order dated 5/8/2016 inter alia passed the following order. page 9 ରୁ last ଦିଟା paragraph ଆଉ page 10 ର first paragraph ଟା quote କରିଦେବି. Stop. Pursuant to such order, the collector again considered the matter and made necessary inquiry and by order dated 11/1/2017 held that the claim of the petitioner does not have any merit. The petitioner thereafter again approached this court in WPC number 6836 of 2017. Stop. This court by order dated 22/8/2022 remitted the matter to the collector to consider the claim of the petitioner afresh after taking into account the documents referred to by the petitioner and by giving him an opportunity of hearing. Stop. Pursuant to such order, the collector considered the matter afresh after giving opportunity of hearing to the petitioner and also directed the block education officer Tumudi Bandha and also the inquiry report submitted by the block education officer Tumudi Bandha, right, letter dated 9/10/2018. After considering all the material on record, the collector came to the definite conclusion that the claim of the petitioner for absorption as gonosekyok and release of remuneration for the period from 30/6/2006 to 31/3/2008 is without any merit. Stop. Said order, copy of which is enclosed as Annexure 8 is impugned in the present writ application. Heard Sri, I'm forgetting her name.
G.R. Kuntia.
G.R. Kuntia, learned counsel for the petitioner, and Sri S.N. Patnaik, learned AGA for the state. Sri Kuntia would argue that the finding that the EGS center had been closed down with effect from 1/10/2005 is perverse, not being based on records. Stop. He relies upon the register and EGS enrollment, copy of which is enclosed as Annexure 4, wherein the CRCC of Jhiripani GP had endorsed his signature, putting the date as 7/5/2007. Stop. Sri Kuntia further refers to some affidavits sworn by the ex-sarpanch of the Gram Panchayat. To support his claim that the EGS center was functioning till 31/3/2008. Stop. Para. See, S.N. Patnaik, learned AGA, on the other hand, would contend that the collector has not only referred to all the documents and records, but also the inquiry report submitted by the block education officer. Stop. He further submits that there is no reason to doubt the authenticity of the inquiry report, as no mala fides can be attributed. Para. uh, this court finds that the collector has taken into consideration several relevant facts, such as several relevant facts to hold that the EGS center was not operational at the relevant time. The collector has taken note of the fact that no funds were released towards girls' uniform to the said EGS center for the year 2006-7. He has also referred to the inquiry report of BRCC Tumdi dated 5/11/2008, along with the statement of Sarpanch and statement of villagers of Gundabaru, and statement of CRCCs, to the effect that the petitioner was not working as EVS volunteer. Moreover, it is the specific finding that the petitioner had managed to obtain the signature of the Sarpanch concerned, assuring the latter to work as EV in the EGS center. The collector further took note of the fact that the EGS center was closed on 1/10/2005 and no center was reopened, nor any advertisement was published for engagement of new education volunteer. In fact, a closure report of the EGS center with effect from 1/10/2005 was also submitted to the State Project Director, OPEPA, Bhubaneswar, by letter dated 17/7/2007 and 8/11/2007 of District Project Coordinator, SSA Kandhamar. Again, reference has been made to the inquiry report of the Block Education Officer, Tumdi Bandh, by letter dated 9/10/2018, to the effect that the petitioner was never engaged as education volunteer by the Village Education Committee Gundabaru, but he managed to obtain signatures of the committee members and villagers with the help of his father, Sri Surjanaran Sorangi, assuring them that he will work as EV at the center. Stop. As regards the affidavits shown by some of the former sarpanches, this court finds that, firstly, there was no occasion for them to file the affidavits in question, and therefore they are to be treated as self-serving in nature. Secondly, the contents of the affidavit run contrary to the statements of the sarpanches as given before the BRCC Tumudi Bandhu. Under such circumstances, and particularly in the absence of any, no, cut up. The, apart from the above, comma, learned counsel for the petitioner has not been able to demonstrate as to how the impugned order is bad in law. It is trite law that this court, sitting in writ jurisdiction, should not ordinarily interfere with findings of fact rendered by quasi-judicial authority unless there is any blatant illegality or violation of principles of natural justice, comma, perverse findings, etc. None of such things exist in the present case. So as to persuade this court to interfere in the matter. In the result, this court finds no merit in the writ application, comma, which is dismissed. Yes.
At number 14.
My lord, the petitioner challenging the order dated 10/2/2023 passed by the loan collector and district magistrate Bhadrak, passed in Anganwadi appeal case number 1/2023 concerning the disengagement of the petitioner who was working as an Anganwadi worker and secured highest mark as per the finding of the order passed in appeal. That, my lord, it is seen that out of 6 applicant, petitioner was awarded with highest mark 66.86.
Yeah, Mr. Patnaik,
Yes, my lord.
you were engaged.
My lord.
You were selected.
Selected and continuing for 2 years, my lord.
Okay. Then what happened?
Then due to I am not belonging to the Anganwadi area,
Who challenged your application?
my lord, the opposite partner 5, my lord.
When did she file that appeal? When अपन fact and अकोले किंतु अपन advertisement के बेला
In the year of 2000,
मौजूद आरंभ किंतु बुझिवा ये
my lord, in view of the advertisement,
2011 advertisement हला.
my lord,
You were selected during in 2011. All right.
under the ground of secured highest mark, my lord.
All right. All right.
My lord.
So engagement order is this.
My lord.
5/10/2016.
Thereafter disengaged,
2011 अपन engaged हले.
my lord.
Then what happened?
Then, my lord, the opposite partner filed a miscase of challenging the resident certificate of the petitioner, which is
Before the sub collector.
sub-collector.
Yes.
Thereafter, there is the found that the petitioner not belonging to the Anganwadi area, my lord.
Yes. Where is that? Where is that?
My lord,
Yes.
the jodi ne. The
Persons of the order.
thereafter the petitioner
So, in that revision 8 of 2016, your certificate is cancelled.
my lord. In view of that revision,
Huh.
I was disengaged.
You were disengaged.
That is annexure 2, my lord.
Annexure 2 is disengaged. Yes, you were disengaged. Then what
After
happened?
there, annexure 3 is the after disengagement, the next highest candidate has been appointed.
This is the opposite party number 5.
5, my lord.
All right.
Annexure 3.
Then what happened?
Thereafter, the petitioner
You filed an appeal.
my lord. And
Yes.
the appeal the
Appeal, what is the finding?
finding, my lord, the petitioner not belonging to
The consul basing on the fabricated report. कौन करे?
no, ठीक है नहीं.
कहेंगे? कहेंगे? Yes, Mr. Patnaik, what is there to interfere? Because we cannot sit in appeal over the order of the sub-collector.
My lord.
And as per
For
this,
that, you have to challenge that order. You have never challenged probably.
Challenge.
Challenge করছেন কোন হিসেবে sub-collector the order of the sub-collector passed in revision cancelling your residential certificate ought to have been challenged. Have you challenged it?
No, my lord.
Then it is binding on everybody. So the collector has rightly accepted it.
Well, liberty to challenging the.
ସେ କେବେ ହେଇଥିଲା
2016
2016 ହେଇଥିଲା ଚ୍ୟାଲେଞ୍ଜ କରି ତାହେଲେ ଇମିଟେସନ କିଛି ନାହିଁ ଆଉ କଣ କରିବା ଇଏ ଅର୍ଡର ବି ବର୍ଷେ ତଳେ ହେଇଥିଲା ନାଇଁ ୟେସ୍ ସୋ
Withdraw with the liberty to.
ଲିବର୍ଟି କଣ ମୁଁ
Challenging the-
ୱିଡ୍ର କରିବାକୁ ମନା ନାହିଁ ଲିବର୍ଟିଟା କେମିତି ଦେବି ତା ଲିମିଟେସନ ଅଛି ନା ନାଇଁ
ଆଜ୍ଞା।
କିଛି ନାହିଁ ସିମ୍ପଲି ୱିଡ୍ର କରିଦିଅନ୍ତୁ ଯଦି କରିବେ ନହେଲେ ମୁଁ ରିଜେକ୍ଟ କରି ଡିସମିସ୍ କରିଦେବି ଡିସମିସ୍ କରିଦେବି କଣ ଅସୁବିଧା
ଆଜ୍ଞା।
dismiss କରିଦେଲେ କଣ why should your client misunderstand you
ନାଇଁ,
if you withdraw it you misunderstood
ଆଜ୍ଞା।
I will dismiss it the petitioner was engaged as Anganwadi worker being duly selected in the selection process in କୋଉ ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ସେଟା
କମରା ବନ୍ଧ ଅଙ୍ଗନବାଡି ସେଣ୍ଟର
କମରାବନ୍ଧ in Komarbandha Anganwadi Center in the district of Bhadrak in the year 2011. Stop. She is said to have secured. No, at the time of submitting application, she had submitted a resident certificate showing her to be a resident within the service area of resident of कोई जगह
କମରା ବନ୍ଧ
resident of Komarbandha हाँ one किए चैलेंज कला था को one
ଅପୋଜିଟ୍ ବାଇ 5 ମାଇଲ
अनिता दास
ମାଇଲ
ना कौन था ना
ज्योति
ମାଇଲ ଅପୋଜିଟ୍ ବାଇ 5
जयंती मलिक से चैलेंज कर तो
ଆଜ୍ଞା
one Jayanti Malik challenged the residence certificate so issued in favor of the petitioner by filing a revision
ସେଟା 5 ପାରାରେ ସବୁ ଲେଖା ହେଇଛି
before the sub collector Bhadrak being Miss Certificate Appeal number 134 of 2015. After necessary inquiry, the sub collector Bhadrak, by order dated 19/4/2016, found that the petitioner is not a resident of Komarbandh but of village Solampur, and accordingly directed the Tahsildar Dhamnagar to cancel the residential certificate. ए अपन challenge करछिन बरे देखो
ଚ୍ୟାଲେଞ୍ଜ
अच्छा हो said order was challenged by the petitioner before this court.
କଲେକ୍ଟର
ना ये WPC करछिन तो कलेक्टर
ହଁ
in WPC number 8422 of 2016. Stop. By order dated 17/5/2016, this court disposed of the writ application, granting liberty to the petitioner to file revision before the collector Bhadra. Accordingly, the petitioner filed Miss Revision Case number
8 of
8 of 2016
Yes.
before the collector. Stop. The collector, by order dated 23/6/2016, held that the residential certificate issued in favor of the petitioner has been proved as not genuine and subsequently cancelled. Stop. Under such circumstances, the revision was dismissed and the opposite party number 5 was directed to be engaged. challenging such order, the petitioner has approached this court. It is dismissed court. This order. This court finds that the order of the sub-collector cancelling the residential certificate issued in favor of the petitioner has attained finality, not having been challenged before the higher forum. As per the extant guidelines, a person to be eligible for engagement as Anganwadi worker has to be a resident of the service area of the Anganwadi center, which in the present case is Kamaraband. The petitioner was found to, petitioner is a resident of village Solampur, as was subsequently revealed in the inquiry conducted by the sub-collector before cancelling the residence certificate granted earlier. The collector, having relied upon such fact, has committed no error. This court fully concurs with the finding of the collector and therefore finds no reason to interfere therewith. The writ application is therefore dismissed. Yes.
Item number 15.
Sure, say challenge करना थी. Sure, बजो बजो काले बाजी जो होली.
May
Yes.
the petition matter relating to selection of Sikha.
Sikha Sahayak. Yes.
The petitioner has challenged the order passed by the opposite party number 1 under Annex 12. Under Annex 12.
Who are you?
I am one of the applicant.
That applicant means who are you? You are against which advertisement?
Against the advertisement made in the year 2011.
Oh, that advertisement.
My-
That says you. ये थोड़े post जो बाहर तला से थोड़े.
Though I have applied, but they have not considered my candidature, even though I have secured higher mark than those who have been selected.
On what ground?
Again, I have represented the authorities, they have not considered.
On what ground your claim was rejected by the commissioner?
Lordship may come to page 13, page 38,
38. Yes.
paragraph 6.
Yes.
Whereas the petitioner attended the office of the DPC SS Bhadrak on 30/3/22, she submitted a written statement stating that she has applied for the same post and the acknowledgement of her application has been lost during the Phony cyclone in the year 19. Thus, it can be safely stated that the petitioner has not applied for the post.
Oh, they have held that you are not a candidate. You are not an applicant.
Para number 4, my lord.
Whereas on verification of records of the present petitioner Mitashri Ragini Naik
Man.
has not applied for any post person. Achha.
But fact remains, under RTI, from the office of the DPC Bhadrak, I came to know that my serial number is 19.
Very good. Where is it?
That is under Annex 13 laws. And those documents were submitted before the opposite party number 1. That has not been considered.
इधर डिटेल हो नहीं तो कौन लिख ले? Application received register.
Application received register pursuant to advertisement published by number.
यार ये कहीं माने PIO लेटर कहीं? Public information officer लेटर कहीं? Forwarding letter. How will we know that?
तापर अच्छी money receipt.
Money receipt हब नहीं क्या? ये से देशन दिला हम जाने किंदी. ये जो देशन तला हम संख्या पटे रहा तंग बगु. How will we know? So they have to they always send a forwarding letter. The PIO sends a forwarding letter, isn't it, Mr. Patnaik?
Yes.
Enclosing all the relevant information. सीधे अपना किंतु करना थी. This information which you have got, you cannot get it simply out of the blue. So somebody must have forwarded this to you. You page 41 पूर्वरु गोटे थिबा दरकार letter पे. Please find out.
सेटा थिला.
Please find out. take it up, we'll take it up next week.
My
Huh? Please
My-
find out. As requested by, as paid for by learned counsel for the petitioner, leave this matter next week.
Item number 16.
এটা হলে কোন হবে না সেটাকে
forwarding টা হলে whether that has been communicated to
so that has been if that is the court finds that it has been communicated to you
my
and you can satisfy the court that yes it was also submitted before the commissioner
my
and but it has not been considered, then I can remand it to the commissioner to consider it.
তাহলে ଦେଇଛି acknowledgement টা ଅଛି আর ট্র্যাকিং রিপোর্টটা ବି ଅଛି
যাহা আছে আপন সেটা তার ଗୋଟେ letter ଥିବ ନା there has to
পেজର ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟ ଦେଇଥିଲେ
no but there has to be a forwarding letter by the
Okay.
public information officer.
DPC office.
Yes,
Okay.
I know.
Item 16.
May I please, my lord? The petitioner filed this writ application challenging the inaction by not implementing the order passed by the additional district magistrate under Annexure 1, page 8.
Yes.
Page 8, kindly have a glance. On the above observation, consider documents material available on record. I am opined the CDPO derivation has not acted accordingly, adhering the government rules and guidelines while engaging HW to the post of Anganwadi worker. The engagement order 21/3/18 issued by the derivation is hereby set aside and she is directed to issue fresh notification to fill up the post of Danpur Anganwadi center following due procedure. And thereafter, the aggrieved person, the opposite party number 6, filed a writ application challenging this order. She filed a writ application before this honorable court. And kindly have a glance. And this honorable court, I have quoted the order, that is writ application number 792 of 2024. And this honorable court, since page 4 of the writ application, I have quoted the order. Since the Lawrence Council has already appeared for the private opposite party, Lawrence Additional Standing Council has appeared advance notice, no further notice be issued. Any action taken pursuant to the impugned order dated 19/12/2023 passed by the Additional District Magistrate Kendrapada in Anganwadi Appeal number 2 of 20 shall be subject to result of the present writ or further orders of this court. And thereafter, and till today, though order has been passed 19/12/2023, till today the order has not been implemented. Now post is laying vacant. Of the
You take instruction, Mr. Das.
Yes,
Just obtain instruction. I'm not issuing notice. Simply obtain instructions. Learned Sri Airdas Learned AGA shall take instructions as to why the order dated 19/12/2023 passed by the ADM Kendrapada in Anganwadi Appeal number 2 of 2020 has not been complied with till date. So, let's this matter the week time here.
5th July.
Huh?
5th July.
Let's this matter on 5th July.
Item 17.
My lord, the petitioner is seeking a direction from the honorable court. Direct the opposite party to dispose of the Anganwadi appeal. The Anganwadi appeal is pending before the additional district magistrate Nuapara.
Or it will direct him to 6/2023. Considering the innocuous prayer of the petitioner.
Yes.
Uh,
Case number 4419 of
2024. On that day, Mr. Ayardas was also the
Airdas Learned AGA accepts notice on behalf of all the opposite parties. He further submits. No, look, list this matter. Okay.
other matters have been listed on 4th April, directed to that date has gone, your lordship.
So we'll fix it up on Quebec coaching.
19th July.
19th July.
Obliged.
19th July. Counter affidavit, if any, be filed in the meantime.
Item number 19.
Same mirror, same.
Same.
Yes, mirror.
Item number 20.
Please to your lordship Miller. It is a very small prayer before your lordship Miller that the
government adopted one scheme, that is Rupantarita Odisha. According to that scheme, my lord, a
Rupantarita
block-wise
Odisha means?
program was initiated. I am the program manager through the Gram Panchayat level federation, my lord. So the by the annexure to
No, এটা বুঝে হয়নি। what is the fact, please?
that is a scheme of the government that the Rupantarita Odisha.
What is the meaning of that? What is the work of that
That
scheme?
that my lord, in block wise, the program was adapted that various development work of the government to be reached before the people. So the program was adopted by the program manager through Gram Panchayat level federation, GPLA. So I am the program manager of that particular Gram Panchayat, my lord. And after that work, my lord, by the annexure 2 series resolution page 11, the GPLA, the CRPCM, the GPLA employees to countersign my program, all the programs. Then, my lord, it was submitted before the video, my lord. Then, though my program money was not disbursed to me, so I filed application before the video annexus 3 page 17. It is pending. 30,000 ଟଙ୍କା ମିଳିବ। That was not
Must be.
given by the
Place kole annexure 3 ଟା ଟିକେ place kole.
annexure 3
Kindly
page
place
17.
it. Kindly place it.
ଦେଖିବାର କାହିଁ ଯେ ମୁଁ ଲୋକନାଥଙ୍କର ପିତା କବିତା ସାଂସ୍କୃତିକ ରେଜିଷ୍ଟ୍ରେସନ ଆମର ଦେଓଗାଁ ବ୍ଲକ BSS ଜିଲ୍ଲାରେ ପାଲା ପ୍ରଚାର କରିଥିଲି ସରକାରଙ୍କ ଆଦେଶରେ।
No, no, no. ଲେଖିବାର କାରଣ ଏମନ୍ତ କି ଯେ ମୁଁ ଶ୍ରୀ ଅମୁକ ଅମୁକ
ଆଜ୍ଞା
ଜିଲ୍ଲା ବଲାଙ୍ଗୀର ବାସିନ୍ଦା ଅଟେ। ତାପରେ କଳା ସାଂସ୍କୃତିକ ରେଜିଷ୍ଟ୍ରେସନ ଆମ୍ଭ ଦେଓଗାଁ ବ୍ଲକ BSS ଜିଲ୍ଲା
ସରକାରଙ୍କ ଆଦେଶରେ 1 ତାରିଖ ସୁଦ୍ଧା
ପାଲା
ଦିନ ମୋର 2 ଜଣ କଳାକାର ପଡିଯାଇ ଖଣ୍ଡିଆ ଖାବରା ହେଲେ ମୁଁ ଅଫିସରଙ୍କୁ କହିଥିଲି ଦଣ୍ଡା ମଧ୍ୟରେ ପ୍ରଚାର କରି ଦେଉଛି। ସାର୍ କହିଲେ କାମ ଗୋଟା ବୋଲି କହିଲେ ପାଲା ହେଉ କିମ୍ବା ଦଣ୍ଡ ସରକାରଙ୍କ ପ୍ରଚାର ହେଉ ଚିଠି ଦେଇଛି। ଯେଉଁ ଗ୍ରାମକୁ ଯିବ ସେଇ ଗ୍ରାମର ନୋଡାଲ ଅଫିସରଙ୍କ ସାମ୍ନାରେ 2 ମିନିଟ ଭିଡିଓ କରିବ ଏବଂ ଭାଉଚରରେ ଦସ୍ତଖତ କରି CRP ଛାଡ଼ିଦେବେ। ସେଇ ଆଦେଶ ପାଳନ କରୁଛୁ। ମୋର ବିଲ୍ କାହିଁକି ପାସ୍ କଲେ ନାହିଁ ହଜୁର? ଏଣୁ ବିନୀତ ଯେ ଏଥିରେ ତଦନ୍ତ କରି ମୋର ପାଇବା ପ୍ରାପ୍ତ ମତେ ଦିଆଯାଉ। କଳାକାର ମାନଙ୍କୁ ମଜୁରୀ ଦେବି।
Yes. money claim
Government already gone, that program stop.
ପଇସା ପାଇନାହାନ୍ତି ଏଟା ରିପିଟିସନ
30,000 ଟଙ୍କା ଦେବେ ସିଏ ମତେ।
ସେ 30,000 ଟଙ୍କା ପାଇଁ ଆପଣ ଆସିବେ।
ମୁଁ ମଜୁରୀ ପେମେଣ୍ଟ କରିବି କେମିତି ତାଙ୍କୁ?
The limited grievance of the petitioner is that he was working as कौन सेटा? Working as program manager
program manager
under the Rupantarita Orissa scheme of the Department of Odia Language and Sahitya Sanskriti Department, Government of Odisha in Bolangir district. He claims to have performed several programs as per the scheme, but has not received his remuneration as yet. So, this court finds that ventilating his grievance as above, he claims to have submitted a representation to the BDO. Deogaon. Take a room. BDO Deogaon on 24/4/2024, which is said to be still pending. Considering the above fact, the writ application is disposed of. Considering the above fact, without expressing any opinion on the merits of this case, merits of the claim of the petitioner, the writ application is disposed of, directing the BDO Deogaon to consider and dispose of the representation of the petitioner in accordance with law within 4 weeks from today. Yes.
Item 21.
Item 21, your lordship, is wrongly listed. The sign of court number 1, old building, your lordship.
Justice VP Satpathi's matter.
My lord.
No, the first matter of the name.
Aye.
List this matter before the assigned bench.
Item 22.
Yes, item 22. Pass over.
Item number 23.
Next week. You are for the petitioner?
Opposite party. Opposite party.
Yes.
Pass over in
I'll pass over.
another.
Pass over कौन? ये इधर पाठक matter था
25 तारीख आसु
Is what you say?
25 तारीख
All right. 25 तारीख को एसपी बनी. आज ये ला जोटा. आज ये ला 21 तारीख मतलब 28 तारीख आसु. हाँ? As requested by counsel for the parties, list this matter on 28th June. Yes. 24.
24.
ये matter टा सही है तो बोलते.
और सबु सरीची लास्ट ओकेजन में खाली से दरमा भी दौनाती ऑर्डर सत्तू भी दरमा देना अप्रैल में रो दरमा से पाई kindly have a glance to last order dated 17/5.
This was the order, Mr. Author.
Yes, my lord. I have
Since
sent
the
it.
government has taken a specific stand in the counter affidavit, the creation and
Yes,
abolition
yes,
of post lights within the exclusive domain of the university. Mr. Rothal and counsel of the university wants to take instructions as to what decision was taken by the
I have
university.
not received any instruction.
अठारह रहने और कितने रखी अपन को 2011 matter.
Hey, Lordship, may dispose of the matter that I don't say to keep it.
In view of the stand taken by the government, the onus will be cast on the university.
As your Lordship, so my contention may be recorded because they.
No, you have, yes, I will say that you have opposed everything that. That need not say that.
That the annexure I have last time I have placed mirror the annexure himself the government has abolished the post. That is the annexure.
No, there is a contradiction.
Yes.
Here, government abolishes the post.
As your Lordship already had the matter.
Well, I'll have to recapitulate.
Yes, Mr.
And at the same time, now the counter government says that it is for the university to take a decision.
Yes.
So what mandamus can be issued, tell me? Except for directing the university to take a decision as early as possible.
As your Lordship.
What do you say, Mr. Patnaik, can you please assess the court? What order can be passed to favor this person? He has been running to the court since 2011.
Proposals were sent to the administrative department. The administrative department sought for the concurrence for the finance department. Finance department rejected. We also.
No, but the government cannot take such a contradictory stand.
Yes,
Yes.
I admit that.
Government cannot take a contradictory. Government says, if we have abolished it, you say so in your counter.
Yes.
But in your counter, you take it differently.
Yes.
The university को क्या कहता है? सिगुड़ की बुझना भी लिख दीजिए. No, but I will have to say that Mr. Ratha has not obtained any instruction. No instruction has been received by Mr. Ratha. I have to say that.
Your Lordship grant 1 week time.
That I will, because there's a judicial order.
Yeah, I have sent a letter, but I have not received the instruction yet, my lord.
No, I'll call it on Monday.
1 week time, my lord.
No, 1 week time of the billing. I'll call it on Monday. This is a 2011 matter.
Tuesday, Lordship.
Tuesday.
और Tuesday हो, मंगलवार।
कल 28 आसु
नहीं 26 तारीख और 25
28 रे तो आसु काहे केते
हाँ, हाँ।
25 रे 25 रे
नहीं
हजरू पाखरे गुटा अछि
कोन
25 रे अछि
अरे 25 रे तो कोन आपण आसीबेनी
आगे
हम कोर्ट को किछि मैटर न आपण आसीबेनी
एपट सब
कोई कोर्ट एते खरा
पार्टर ना मु आसु को डेट रे मु एब्सेंट नाही
नहीं कोर्ट कोन आपण मैटर फिल आसीबे न आसीबे को एते खरा के कोर्ट आउतल
सिको भगवान
आउतल आ सेदिन मैटर अछि मु आसीबे न आसीबेनी ई कोन
नहीं नहीं
28 तारिख को करबा बेटर होबे एकाथरे
Yes, madam. Yes,
yes, Sri Ratha learned counsel appearing to the university.
अब खाली मु कहबी
how can I call it so sorry?
2009 रे गवर्नमेंट चिट्ठी उठे देइचंती तादरे कहिचंती पारा 3 रे से लास्ट ओकेजन रे भी गवर्नमेंट एडवोकेट देखौले
It has replied to
thereafter considering the prayer of the petitioner in case number 481/96 the honorable high court passed order on 16/1/97 to give appointment to
L. Patnaik. Why this order was not carried out as done in case of other two persons, though vacancies are available at that time?
There is another aspect. The base level vacancy was which was abolished. That was taking into consideration the financial stringency that the state was undergoing in 2011.
Austerity measure.
Austerity measures. Those austerity measures do not exist anymore now. That is one part. Second part, the government itself appears to have taken a contradictory stand,
Yes.
casting the onus on the university.
University.
Anyway, we'll consider that. I'll consider that on that. Her further arguments. Sri Ratha Leonard, her further arguments. Sri Ratha Leonard Council applying for the university submits that he has not received necessary instructions from the university authorities and therefore requests for a short adjournment. So, since this is a case of the year 2011, this court is ordinarily not inclined to grant further time. Stop. However, as a matter of last chance, as the last chance, the matter is adjourned to 28/6/2024. Parties are requested to come ready for hearing. On that day, we'll close it. If you want to file any further thing, say.
Last occasion में जो salary पे direction निकला था April में
letter I have sent later.
Further, the university authorities shall release the current salary of the
April में
current salary will कर देंगे. Yeah, the salary of the petitioner for the month from April 2024 onwards. Yes.
Okay. Item 25.
Lordship, there are three IAs on the board.
Limitation, settlement,
Respond number 1, substitution, abatement, and limitation methods.
Copy was not solved, my lord. I'll take instruction of solving.
Sir, respond number 1, my lords.
Let copies of the petitions, interlocutory applications. Be served upon the council for the respondents. Respondents?
1, 2.
List this matter next week.
नहीं सर appear करूँ अभी टाइम सप्ताह खंड
Substitution allow election appeal करियो. Let the substitution be allowed then.
Yes.
I am allowing the substitution. What do you say?
Let him solve copy.
Why? What have you got to say on the substitution? He wants to substitute. What have you got to say? Tell me.
Next week.
Next week.
Item 26.
Here I am for the respondent number 1, my lord.
For substitution, was respondent
My
number
lord, I am
15?
for the appellant. This matter was listed, my lord, yesterday. I have listed the IAs in a tabular form.
Very good. So who died? Respondent number 24.
24, respondent number 15.
ନା ମୁଁ ଏମିତି କହିନଥିଲି ଆପଣଙ୍କୁ କାହାର କୋଉଟା କୋଉ ରେସ୍ପଣ୍ଡେଣ୍ଟ ମଲେ ତାଙ୍କର ପିଟିସନ ଫର ସବଷ୍ଟିଟ୍ୟୁସନ
Yes, ma'am.
ଫର ସେଟିଂ ଆସାଇଡ୍ ଫର ଆବେଟମେଣ୍ଟ ଆଣ୍ଡ ଡିଲେ ଇଏ ତିନିଟା ସବୁଥିରେ ତିନିଟା ରହିବ ଯଦି ଡିଲେ ହେଇଛି
My lord, respondent number 24, there is no delay.
there is no delay so directly
Yes, my lord.
No delay. Acha. Respondent number 7, there was delay. So abatement.
My lord, respondent number 7, we have filed an IA, my lord, for abatement of the RFA. Because, my lord, respondent number 7 during.
We will consider it later.
My lord, then.
अगर substitution काम सरो तब we will consider it.
Okay, my lord.
Then respondent number 15, no delay.
No, my lord, there is delay, but we have not filed delay and setting aside abatement.
कौन कराजी होता है?
We will take steps for respondent number 15. Number 77 of 18, let it be pending, my lord.
Yes. तबरे?
My lord.
Respondent number 16.
16, my lord, same as respondent number 7, let it be pending. My lord, 495 of 22.
Yes,
Appellant number 3,
no delay.
no delay, my lord.
Respondent number 14,
Respondent number 14, my lord. Setting aside abatement and delay have been filed.
what is the delay?
Delay, my lord.
ठीक है आगे सब कॉल कर लो तब मैं डाक देगी then respondent number 31 there's no delay probably
No delay.
no delay all right then respondent number 29 there is
Delay, my lord.
delay with certificate side appointment and all then respondent number 2 no delay
No delay.
no delay all right आइए उड़ा करूँ तो आइए रे अगर तुम respondent आइए रे 77 of 2018 steps for limitation and setting aside abatement be taken within a week
मतलब 2 weeks.
कहीं limitation petition file करोगे abatement setting aside abatement file करोगे आपको
मतलब
within a week yes तब आइए 26 of 26 तक आगे कर दोगे पर सीरियली बुक कीजिए चलिए 26 of 2018 this is an application for substitution of respondent number 24 who died on you have the date
yes, my lord.
कौन ready room तो गया these are very cumbersome matters you have to be ready with all the facts who died on such and such day. Application for substitution has been filed in time
12/10/2017.
12/10/2017 within 90 days it has been filed
My lord, filed on 7/1/2018.
oh 90 days since the right to sue against said respondent survives the application for substitution is allowed the LRs of respondent number 24 as mentioned in the schedule
Yes, my lord.
as mentioned in the schedule be substituted as respondent numbers 24A B जहाँ है जो जैसे जन है ना कोई देखिएगा अपन निजे करें तापरे आइए नंबर 495 of 2022 this is an application for substitution of appellant number 3 who died on
25/10/2020.
25/10/2020
My lord. It was filed on my lord 3/5/22, but COVID period.
তাহলে delay হবনি
No, my lord. Therefore there is no delay application.
since the application since the appellant number 3 died during the COVID-19 pandemic the application for substitution having been filed on
My lord, 3/5/2022.
3/5/2022 is to be treated as being filed in time in view of the decision number of standing order High Court of Orissa the prayer for substitution is therefore allowed as the right to sue survives in favor of the LRs of the deceased appellant. Accordingly, the LRs as per the schedule be substituted as appellant number 3A B C yeah. ସେମିତି ସେ ଆରଟା ବିଷୟ ହେଇଥିବ
ଆରଟା ଟିକେ delay ବେଶୀ ଅଛି.
ବୁଝିଲେ आइए 578 of 2022 हाँ 577 टा कर दूं से delay नहीं 577 of 2022 this is an application for substitution of respondent number 31 who expired on The application for substitution having been filed on it dash is in time. It's the right to sue survives against the LRs of the deceased respondent. The application is allowed.
31 died on 2/11.
The LRs of respondent number 31 be substituted as the respondent number 31 A, B, C, D. IA 578 of 2022. इधर delay ratio है
5 delay ना लो
चिरा कौन करेंगे ये तीनटा को मिसेक ना लो है ना गोटे या पूर्व भी ये तीनटा को मिसेक नहीं. This is an application for substitution of respondent number 29 who died on dash. There is
29/7/19.
29/7/19. 2019. The application for substitution has been filed on
15/5/22.
15/5/2022. Considering the grounds cited, the delay in filing of the substitution application is controlled. Stop. The order of abatement of the appeal against respondent number 29 is hereby set aside. Further, since the right to sue survives against the LRs of the deceased respondent, comma, the application for substitution is allowed. Let the LRs of the deceased respondent be substituted as so and so forth. IA 26 of 2018 I have already done.
Yes, my lord.
No. Then IA 495 of 2022. Yeah, 495 be done. Then we have IA 577 of 2022, respondent 31 be jaichi.
Yes, my lord.
IA
96 of-
IA 951 of 2022.
Respondent number 2, my lord.
This is an application for
My lord, on time.
this is an application for substitution of respondent number 2. The application is in time. Since the right to sue survives against the LRs of the deceased respondent, the application is allowed. The LRs of deceased respondent number 2 be substituted as respondent numbers 2, 3, 2, A, B, C. Hello? Yes.
Respondent
IA.
number, respondent number 14, 496.
That has been done. Sabu sarigala. Khali jo अन्य matter उड़ा रहा है. अब दी तरह लगा. IA 76 of 2018 and 78 of 2018.
76
Let's just list these applications for consideration at a later date. Hello? We will have to issue notice to the
Yes, my lord.
issue notice to the substituted LRs of the deceased appellant, public respondent, duty jahab. By registered post with AD, fixing short returnable date. The requisites be filed within 3 working days. List the matter after service of notice. I would entry model con IA.
My lord, stay of further proceeding in final decree. Yes.
What do you want to say? Yes. IA 522 of 2017.
Let the final degree proceeding continue, but the seal signature shall not be.
Yes, that is an order. Exactly, that is the order.
Yes.
In the interim, it is directed that proceedings in TS number 126 of 1993 bracket FD shall continue that the decree shall not be sealed or signed without leave of this court. No, shall not be signed, sealed or signed till the next date. तापरे आइए 1222 of 2022 कौन ये इंटरव्यू मॉडल थिला इंटरव्यू मॉडल थिला आज्ञा
रिसर्फेसिंग पे
यस
जो एशियन रिसर्फेसिंग ये रे एटा एक्सटेंशन पे हमें देइछु
दरकार नहीं हो इंफ्रास्ट्रक्चर आइए इज डिसमिस्ड एज इंफ्रास्ट्रक्चर नहीं एटा अपन वक्त है अपन जो बात करके फाइल का सब एप्लीकेशन बात करके जोड़ा डेट पर चढ़ा दो तो रखी बचे यस आइटम 27 item 27
the notices have not been made sufficient, madam.
Respondent number 14, 16 and 18 with the same postal report address expired.
Yes, madam.
You will have to take steps.
Yes, madam. We will take
Steps for limitation be taken against respondent number 14, 16 and 18. In so the other respondents re कौन करिए?
madam.
Press notice ना बे?
Madam, 2 and 9 refused.
2 and 9 refused. हाँ. Since notice issued on respondent numbers 2 and 9 was refused, the same is held to be sufficient. बाकी जो रह गए
Baki time, my lord, we will take fresh steps. And 12, 13, 17, my lord, 18 not back. But the
postal tracking report कौन कौन ची? देखिए at flags A1, A2, A3 देखिए जरा postal tracking report तो थाई परे A1 delivered. The postal tracking report reveals that notice on respondent numbers 12, 13 and 17 has been duly served. Gola. Fresh.
my lord, arrest fresh steps.
Fresh steps for issuance of notice be taken against respondent numbers 1, 4, 5, 6, 7, 8 and 11. Requisites be filed within 3 working days.
Lord, also 3 and 10.
3 and 10 कहेगी?
Lord,
अच्छा
address you move.
अच्छा 1 जगह 3 and 10 क्वेश्चंस जहाँ रहे तब फिर 3 and 10 ऐड कर दो है ना? Issue fresh notice by registered post fixing returnable within 4 weeks. Requisites be filed within 3 working days.
My lord, 3 weeks, जो 2 weeks time, my lord. My lord, address टा टिके आनिया पे पड़ियो कारण तंग address बाहर.
Requisites be filed within 2 weeks. हाँ. There's the appeal after service of notice on the respondents. Yes.
Item 28.
Yes, madam. There is a delay about 2 years in filing the appeal. Is suit for declaration of the sending executed by one person in respect of joint property was dismissed. That was confirmed with the appeal. The petitioner is done with this lady, middle caste lady, due to some family dispute at her in-laws house. He resided outside of the village.
What is the matter? Tell me.
Matter that the suit line is a co-personal property that has been sold to the defendant respondent without the consent and knowledge of the other co-personal, the present victim.
Well, issue notice. I 450 of 2024 issue notice to the respondents. John a respondent. Respondents notice to the respondent by registered post with ID returnable within 4 weeks. Requisites be filed within 3 working days. List this matter on
In the week commencing 5th August.
in the week commencing 5th August. It a hearing pen. It
Item 29. Appeal. Two ayes are placed before my lordship. One is for dispensing of filing of certified copy of the trial court judgment, and another is for delay.
Trial court judgment appellate court file is.
Appellate court file I have applied it. For the time being, it may be dispensed of.
IA 451 of 2024. filing of the certified copy of
Annexure 1. The trial.
the trial court judgment and decree is dispensed with for the time being. How much time would you require to file the certified copy? 2 months' time is allowed to file the certified copy. Yes, IF 452 of 2024.
Another is there is a delay of 70 days in filing the second appeal, my lord.
Yes, what is the matter?
My lord, the oral cell under section 9 of the TP Act was disbelieved by the learned trial court in spite of the evidence adduced by both the appellant, which was duly supported by the respondent.
So how is it a substantial question of law?
My lord,
How is it a substantial question of law? He does not accept, does disbelieve the evidence. So how is it a substantial question of law?
he disbelieved the.
Yeah, let him disbelieve it. He did not accept it. What is wrong in
He
it?
disbelieved.
So how can the appellate court substitute its interpretation of the analysis of the evidence?
Is below 100, my lord.
Yes.
That is under section 17. It does not require any
Discussion. Yes.
So oral cell is permissible.
Oral cell is permissible.
Yes.
You say that he disbelieved.
Yes.
So on the evidence he did not accept it.
He disbelieved on the score, my lord. The suit was valued at 2,100 in the year when the suit was filed. That is in the year 2022. The suit was valued at 2,100, and he take that value as the value of the property.
That's a different matter. So let us see.
The sale was performed in the year 1978. The original owner of the property is the performer defendant, respondent, my lord. That is one
This is a suit for title, isn't it?
Yes.
Title in interest.
My lord.
So you adduced evidence.
My lord.
That evidence was disbelieved. What is wrong in that finding? That is what I am asking you. This is a second appeal, not a first appeal.
No, my lord. That is, I am aware of that, my lord. The only lordship may kindly peruse the judgment at page 17, internal page 10.
Yes.
Of annexure 1. Issue number 1, 2, and 3. The learned trial court has.
Yes, please place it.
On perusal of the pleading of the parties and material available on record, and so also the testimonies of the witnesses, it is found that the suit land is situated at Mouja Bojobedal under Rorua PS, district Moirvanj, and the suit is valued at 2,100 for declaration of right title interest and confirmation of possession and injection.
Yes. Then
He has taken the value of the suit as 2,100, the property value, and therefore he interprets section 54 of the TP Act in a different manner.
let us see.
That is at page 15. Running page 15, internal page 8 of the judgment. As per section 54 of the Transfer of Property Act, sale is transfer of ownership in exchange of a price paid or promise or part paid or part promise. Such transfer in case of tangible immovable property of the value of 100 rupees and upwards, or in case of a reversion or other intangible thing, can be made only by a registered instrument. In case of tangible immovable property of a value less than 100, such transfer may be made either by a registered instrument or by delivery of the property. Here, the value of the property is 90, and he disbelieved that. Last paragraph, as per the mandate of section 54 of the Transfer of Property Act, it is the duty of the plaintiff to prove that on the day of purchase, the value of the suit land was 90. He failed to produce a single document to show that the valuation of the property at 90. No, under oral sale, my lord, section 9, there is no need of any document to be produced.
No, it's not a question. The court held that the valuation of that the property is valued at rupees 90. There is nothing to show. So
no document is needed.
You are oral sale. Even you forget about that. Let us forget about that document. What was the evidence, oral evidence adduced to show that the value of that particular suit land was 90?
That is the evidence of the That is the evidence of the Lordship may kindly peruse.
Then let us come to the appellate court's order.
Appellate court has also not discussed anything, just reiterated the order of the learned trial court.
Let's see how he has dealt with it. What happens is here he has disbelieved your oral evidence, and since there is no documentary evidence showing the valuation of the land,
Oral evidence of the person who has sold the land to my father. That is respondent number 2. That is issue number 4 and 5, page 12, internal page 5. That is there. It appears from the evidence of PW2 plaintiff that the performer defendant number 1 was the original owner of the suit land, measuring ticket hearing plot number.
you can come to page 30. Please paste this paragraph, the learned trial court.
Yes, yes.
So to place court.
That I marked it. The learned trial court is conscious of the statutory provision of section 9 of the Transfer of Property Act governing oral sale, and at the same time felt prudent to analyze the provision contained under section 54 of the Transfer of the Property Act. As per the mandate of section 54 of the Transfer of the Property Act, it is the duty of the plaintiff to prove that on the day of purchase, the value of the suit land is 90, which is the consideration amount in the alleged oral sale transaction. But no document to that effect has been filed, for which this court has a reason to believe that the plaintiff has not approached the court in clean hand. So, both the courts has harped on a point that the plaintiff is duty bound to place a document with regard to that oral sale, which is not a mandatory provision under section 9 of the.
Even if there is no document, but the court has to be satisfied that the oral sale is not a sham. So it has to be shown. Otherwise, through oral evidence, someone valuation that
is from the original owner has stated in his evidence.
No, orally is a self-serving. It's a self-serving oral agreement. We do not know what has happened. Anyway, all right. 452 of 2024. Issue notice to the respondent by registered post with AD. Returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter after service of notice.
Okay.
Yes.
Item 30. The IA is for dispensing with the filing of the trial court judgment. But today I have filed the certified copy.
Filed?
Yes.
Then counsel to the petitioner submit that he has filed the original certified copy of the judgment of the trial court. The IA is therefore rendered infructuous. Yes.
So, urgency is there. After dismissal of the suit and past appeal, suit was for partition and declaration that gift deed is void. Now it is a shop room. The defendant number 1 who has acquired by gift deed. Now, bhangi dei sarani dukan shop room ta.
Well,
so
next week for admission.
Okay.
See, you serve a copy of the IA on him.
Caveat person copy service.
All right.
I have entered through caveat.
Here.
Miller.
So next week we'll take it up for admission.
Miller.
After admission, the IA will be taken up.
Okay. Miller. Hon'Ble.
Item 31.
Item 31.
Item 14, I am for opposite now 5 matter. No one is here. The person is.
You'll have to pass it over.
These are bar excellent. Yes, these are. These are district.
So dispose of kar do. None appears on repeated calls. The earlier occasion also, date application was dismissed for default of the petitioner and was subsequently restored. So, since there is no appearance, it is presumed that the petitioner is no longer interested to prosecute the petition. The writ petition is therefore dismissed for default. Yes. For non-prosecution. No, dismissed for non-prosecution.
ସେମିତି ସେୟା କରିକି ଦୁଇ ହଜାର ବାରରୁ ଚାଲିଛି।
देखिए सेତେବେଳେ देखिए
32 May I please your lordship.
yes
My lord, regarding election of Hon'Ble worker under the opposite party, my lord, can I have a glance to page 17, my lord. This is the advertisement, wherein the specification was serial number 1, ଯୋଗ୍ୟତା ପ୍ରାର୍ଥିନୀ ଦରଖାସ୍ତ ଆହ୍ୱାନ କରାଯାଇଥିବା କେନ୍ଦ୍ର ପରିସର ଅଞ୍ଚଳର ସ୍ଥାୟୀ ବାସିନ୍ଦା ହୋଇଥିବେ, କେବଳ କେନ୍ଦ୍ର ପାଇଁ ଚିହ୍ନଟ କରାଯାଇଥିବା ସର୍ଭେ ତାଲିକା ମଧ୍ୟରୁ ଯୋଗ୍ୟ ପ୍ରାର୍ଥିନୀ ଦରଖାସ୍ତ ଆବେଦନ କରିପାରିବେ ଏବଂ ସିରିଏଲ ନମ୍ବର 2 ଟୁ ଦି ଲାଷ୍ଟ ପ୍ରାର୍ଥିନୀ ସ୍ଥାୟୀ ବାସିନ୍ଦାର ପ୍ରମାଣପତ୍ର ଅବିକଳ ନକଲ ଅନଲାଇନ ମାଧ୍ୟମରେ ଅପଲୋଡ କରିବେ, ବିଜ୍ଞାପନ ପ୍ରକାଶ ପାଇବାର 5 ବର୍ଷ ମଧ୍ୟରେ ହୋଇଥିବା ଆବଶ୍ୟକ। Then my lord, coming to the selection list at annexure 4 page 21.
yes
I am at serial number 7,
yes
the secure mark, and the person who has been selected, it is at annexure the serial number 4. Can have a glance.
yes she has more marks than you.
Remarks was application status verified and residence certificate not valid. This was typed. Nice. When the very residence certificate is not valid, but despite of that, they have selected her and given the appointment during pendency of this writ application. Apart from that, when they have been directed to file the counter, they have filed the counter.
You have not challenged this selection of that serial
That
number.
annexure 4 I have challenged. Despite
Well,
that
no,
candidate-
no. Did you not file any appeal?
No, my lord, it is the Hon'Ble worker, my lord. I am challenging the process of selection.
I think if somebody has been engaged and you want to challenge the engagement, it has to an appeal has to be filed before the ADM. Isn't
I
it?
have not challenged, my lord, because they are going to make any appointment. For that, I have challenged the
No, for
process.
that you could have also filed it before the ADM. I think I asked you this question on the last
That
occasion.
is a appeal provision. This is Hon'Ble worker.
Guidelines dated 25/2007.
23
Either alternative remedy exists, why should this court interfere? Even though counter has been filed. Because you are challenging the selection of somebody else. The
Yes.
present opposite party number
Opposite band number 5.
6.
6.
So you have to challenge it by for an appeal.
For the ADM.
No, before the ADM. So why?
In the meantime, also counter has been filed. I have filed the reason. Interim order was also passed. Fact remains, my lord. They have later on, they have applied for the same. Can have a glance to the annexure C by 1, B by 1, B by 5, C by 5. At page 10 to the counter. Counter affidavit filed by the opposite party.
Yeah, but Mr. Mahanti, notwithstanding the fact that for some reason, I don't know why this was,
Dragged so long.
I mean, yes, on the first date itself, it should have been remanded to the ADM.
Should have been.
2023 will say, I can grant you that liberty, Mr. Mahanti. It is revised year as you know,
March 2023 रे ठीक है March 2023 रे revised guideline
Dele amku dele amota
clause number 8 अनुसार
clause number 8 on sir.
The advertisement was later to.
So you will be losing a forum.
Advertisement is 2023.
yes March
July 23.
This came in 15th March 2023, this new. ଦେଖନ୍ତୁ Mr. Mahanti, ପୁରୁଣାରେ ବି ଥିଲା ନୂଆରେ ଦେଖନ୍ତୁ ଆହୁରି ସ୍ପେସିଫିକ ଅଛି ପୁଣି ସେକେଣ୍ଡ appeal ଗୋଟେ ଅଛି to the RBC. So you will be losing 2 forums. I would suggest you withdraw it with liberty. Let me not pass any order.
Second appellate authority.
Yes, so you will be losing two forums.
ନୂଆରେ ଅଛି ଏଇଟା।
ନୂଆରେ ଅଛି, ଆପଣଙ୍କ ନୂଆରେ ଆସୁଛି। ଆପଣ cause of action has arisen after issuance of these revised guidelines.
15/3/2023
ନାଇଁ ନାଇଁ ଆପଣଙ୍କର ହେଲାନି ଶୁଣ ସାର୍
ଆମେ ଜୁଲାଇରେ।
ଜୁଲାଇରେ ହେଲା। What will you do? If you seek withdrawal, I can grant you liberty referring to this. And you will file a petition for condemnation of delay, which will be definitely considered.
Or taking into consideration the counter and reject.
Counter affidavit is the factual aspect को जीवा पड़ेगा ना. There are two forums. ADM
Appeal
and second appeal before the
Appeal
RDC.
before the RDC.
MLO third.
Because in the meantime, ignoring all these aspects, they have issued in a.
That will, I will also, if you want, I can also make that observation that any appointment made has to be subject to result of any challenge.
That is the order.
That is the order before we read the application. So now that, anyway, in course of hearing, the State Council has drawn attention of the court to the revised guidelines dated 15/3/2023, issued by the Department of Women and Child Development from our Government of Orissa, which provides the remedy of appeal before the ADM, no, District Magistrate / ADM against in respect of complaints regarding selection of Anganwadi workers, and also second appeal to the Revenue Divisional Commissioner of the concerned division. Reference is made to clause number paragraph 8 bracket G of the said guidelines. Since alternative remedy exists, the writ application is disposed of, granting liberty to the petitioner to prefer appeal in terms of the provisions of the revised guidelines within 2 weeks from today. If such appeal is preferred within the stipulated period, along with petition for condonation of delay, the appellate authority shall consider the same in accordance with law, having due regard to the fact that the petitioner, rightly or wrongly, had approached this court within the period of limitation in the present writ application. Stop. Further, this court, having already passed an interlocutory order
17
to the effect that any appointment to the post of Anganwadi worker being made in the meantime shall be subject to the result of the writ application, it shall be open to the petitioner to move the first appellate authority for passing of similar order. Stop. That's all.
May pay for stipulation or time period by that proceeding will come.
नहीं कौन सी second appeal भी अच्छी
नहीं, so far this first appellate authority is concerned. File it within a.
Further, the first appellate authority shall dispose of the appeal as early as possible, preferably within a period of.
Notice has to be issued to the respondent.
That's something. Preferably within 2 months after granting opportunity of hearing to all necessary parties.
Item 33.
In this case, my lord, the petitioner earlier approved this honorable court. This honorable court directed to the opposite party number 1 to take decision with regard to relaxation of their operating limit.
You filed your counter affidavit.
My lord, in this case, my lord, will adopt one counter, my lord.
All right.
But We have discussed it, my lord, but we have not yet final.
You said that the decision not to relax the upper age limit is a policy decision of the
Yes,
government.
my lord, that is what, as per the previous round litigation, my lord, we have already considered the representation, we have passed the order. But we'll file the counter, my lord, counter by the opposite partner one. Some time may be granted.
Yes, Mr. Saktat.
The opposite party number one should.
Yes, but like Leonard AG requests for some time to, requests for further time to file the counter affidavit. List this matter on December, 12 July.
That also.
19 July.
Yes.
Counter affidavit, if any be filed in the meantime, after serving copy on the other side.
Yes, well, it is in respect of, I don't know, 33, 34, 35.
Saboda. All.
These cases are identical.
You may file one counter with
That is what I'm saying. I have already told them.
My lord, the IA, my lord, filed, my lord, with regard to, my lord, for reservation of one seat, no one post, my lord. Because, my lord, recently, my lord, my lord, the division bench in writ appeal, my lord, so far as 20,000 of schematic teachers, my lord, they have to be given appointment, my lord. And pursuant to the judgment passed by this honorable court recently, my lord. So there is apprehension, my lord, if the post is filled up, my lord. Your lordship in the case of Mamta Naik case also directed to fill up, to give appointment so far as existing vacancy, my lord, backlog vacancy of 2015, my lord. So there is apprehension, they may fill up all the posts.
Even if these cases are filed in one, my lord, but actually the petitioners are 12 in number in one case. There are several cases, several petitions are there. So without interfering with the recruitment process, I will pray, my lord, I will file the counter, my lord, positively by the next date, my lord, and the matter will be heard. Because it is a
so many posts, so many posts are to be
it is relating to a recruitment where the petitioners are actually not eligible.
I know.
That
because of that upper age limit.
Ground of
Consider on that day.
Your lordship,
No.
Any appointment made in time.
How? What you have instance?
Subject to result of petition, if lordship. No, I am not
Yes.
Any selection made in the meantime shall be subject to the result of this writ application.
All the cases I
whatever. Yes. Interim.
There is a matrimonial dispute between husband and wife, your lordship.
Yes.
And wife initiated 3 other proceedings under the judgeship of Halaswar. And husband had one divorce proceeding at Baripada.
Just a moment, Mr. Jana. There flag B9. Noting a flag B9.
Last move check pochade file
No system. What happened to that mediation?
That mediation subsequently posted to 25th. Further mediation.
What? Is fixed to 25th. Well, it will come after that.
And team shows my interim order may kind of continue.
Yes. Report of the mediator indicates that the next date of mediation is fixed to 25/6/2024. Hence, list this matter on 25/6 July the first week. 5th July better. Yes, Mr. Jana, 5th July. 5th July.
Till shows interim order.
Interim order is all right. Interim order to continue till then. Yes.
Do no pleasure.
Item 37.
Lord, I'm no opposite party. Needs 2 weeks time for filing of counter.
Mr. Ponda,
the petition interim order to continue. Interim order.
Counsel for the opposite party seeks 2 weeks time to file counter. List this matter on 12 July. Counter be filed in the meantime. Interim order to continue.
Item 38.
On 15 July.
12th for it, our next date.
Next.
19 July.
Hearing on behalf of respondent.
Raviraj Mahanti, advocate and associates have entered appearance for opposite party number 1.
Lordship.
Opposite party, sole opposite of the opposite party. The filing wakalatnama in the court. Appearance be accepted. Yes. Pahla mediation jibe?
Lordship, we are interested for mediation. Lordship.
You are the husband.
I am the husband.
Yes, what do you say?
I'll take instruction, Your Lordship, whether the wife is.
Mediation by instruction. All right, I'll call it on.
A short date may be given, Lordship, anytime next week. I can take instruction in the meanwhile.
All right. Then counsel for the parties request for some time to obtain instructions as to if the dispute between them can be settled amicably through mediation. Let's this matter next week.
Gratefully.
Item 39.
The interim order may be continued.
Interim order to continue.
In 9 mile. Transfer from Bargarh to Sonpur. My lord. On the ground that, my lord, I am the wife, I have a child. And another party is some proceeding also pending before the Sonpur SDM.
Any chance of settlement?
Chance of settlement, my lord, I have taken advantage.
You are the wife.
I am the wife.
Yeah.
She is agree, my lord. But somehow some cruelty, due to some cruelty.
Yeah. I can refer it to mediation. Mediation and the local mediations and
Sonpur, my lord.
Sonpur.
The proceeding is pending at Bargarh.
Bargarh.
Bargarh to Sonpur. Sonpur. How far are they? They are very near.
Yes. 100 kilometers.
After hearing learned counsel for the parties. After hearing learned counsel for the parties for some time, this court is of the view that the dispute between the parties is such as can be settled, as can be amicably resolved through the process of mediation. Learned counsel for the parties also are of the same view. They also submit accordingly. In such view of the matter, the secretary, let the records be placed before the secretary DLSA Sonpur, who shall appoint a mediator from the panel and proceed accordingly. The parties are directed to appear after receiving notice from the mediator and to render full cooperation in the mediation proceeding.
Yes.
Release this matter. August. On 12th August.
My lord.
Interim order shall continue. Till then.
Item number 40. That's the word that has been, Your Lordship can have a look at page 22 of my IA.
20,
paragraph 15. Your Lordship have given everything, last 3 lines.
Sir, page 22.
Since the benefit has already been granted by deducting 5 years from the date of receipt of granting it, the dues admissible without deducting 5 years from the date of receipt of granting it shall be paid. That should be the receipt of date of approval. Your Lordship have directed in all the paragraph the approved date of approval. And Your Lordship can see, I have stated in
the approved dates of the appointments.
the approved date of
date of approval.
It is admissible without deducting 5 years from the date of receipt of granting it. That should have approved date of appointment.
Without deducting 5 years from the date of approval.
Granting it is different date of approval. My
date of approval of the account.
Yes.
Yes, what do you say?
Well, I have not the copy of the IM. I don't know.
Sir, the account can do, sir, in receipt. If your office doesn't supply you, what can I say?
That copy is not with me. That is what I am submitting.
Only
not that.
only. You can very well, if you go through that, you can understand. Everywhere it is the receipt date of the approved date of appointment. But
Yes. since the benefits have already been granted by deducting 5 years from the date of receipt of granted aid.
Yes.
Granted aid जो दिन पहले से दिन तो 5 वर्ष काटेगी से करो. Applying that amended.
Yes, ma'am.
The due, so direction of that, the dues admissible without deducting 5 years from the date of receipt of granted aid shall be paid to the petitioner. Actually, what I meant is, it should have been clarified that it should be from the date of positive.
Date of approved date of appointment.
May I pray, my lord, can it be taken up on Monday?
It can be taken up on Monday. Let him.
I'm not difficult.
Actually, we can say.
Yes, I want that Mr. Mahanti should come prepared.
Mr. Patnaik.
Patnaik, sorry. Sir, Mahanti Patnaik.
Sir, no comments.
Along with my laws, another is that.
No, the dues admissible. What I meant is, এই যেটা আপনারা মানে ডিডক্ট করলে গ্র্যাটিনেড সেইটা ন করি কি করতে বলি মু কইছিলি তা ন করি কি
I have stated that's a typographical mistake.
So we can say that the dues admissible from the date of
approved date of appointment.
Deducting those 5 years from the date of approval.
Like sir, page 8
Page 8.
Yes, of that the paragraph 2 of the judgment.
Yes.
That is joining approved by the government is 83. Date of release of granting aid is 88. So that what your lordship meant from 5 years without deducting from date of approved date of joining. On a cogent reading, my learned friend will agree with me.
So they may have challenged it also. Even if you challenge it, I can modify it.
Yes.
I don't know whether they have challenged it or not.
Like that we have not obtained the certificate of payment.
All right. So let's this matter on Monday, as per for Monday.
Yes.
Along with my lords, that another I have filed for another case. Both came together.
The cases.
That is 47777 of 2024. That is Bastia's case.
Next, read petition better.
Sir, arising of WPC 5897 of 2004.
Okay, arising out of along with WPC number
5897 of 2004.
2004.
ସେଥିରେ ମୁଁ ଦେଇଛି IA ଟା ହଉଛି
wherein IA number
47 of 2024.
7777 of 2024 has been filed. Yes.
Yes, my lord. So that my lord will come prepared.
Record room कहीं जीतो हमें भी dispose of करते record room कहीं जीतो दल मन Tuesday कर दो काले गोटे दिन ये हो
Okay, no problem, sir.
Tuesday कर दिन है ना all right.
Item 41 permitted to withdraw.
Permitted to withdraw.
Item 42
Secretary will receive each.
Item 42.
Fine.
Sir. Yes, sir.
Item 42. There is a slight error in your lordship's order, my lords. Your lordships had directed that list this matter in week commencing 24 June 24.
Sir, which order?
My lord's last order. This is the order. 25 to 2024.
File कहीं इधर नहीं 25 रो order कहीं इधर नहीं scan नहीं होता देखिए चलो I am looking at the wrong order. Yeah. Scan करना चाहिए. List this matter in the week commencing 24
June 24, interim bail granted by this court-wide order dated 19/3/24 stands extended till 20th June 24. Actually, your lordships had in court said 28th June to 8th June, and the matter was supposed to be listed today, my lords. 28th June.
So we'll take it up on we'll make it 28th June. What is it?
My respectful submission, my lord. If the matter will be sent to the mediation center, Cuttack.
We are ready for that.
Because
mediation center. Considering the submissions, the paragraph 6 of the order dated 25/2024 is modified only to the extent of substituting the figure 28 instead of 20th
June
20 है ना voilà next para the bail application is taken up in hearing in course of hearing learned counsel for the parties submit that the dispute between them can be resolved, can be attempted to be resolved.
Yes.
Amicably through the process of mediation.
Well,
Such being the submission, let the records be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful.
well,
The parties are directed to appear pursuant to notice received from the mediator and to render full cooperation in the mediation proceedings. List this matter in. नहीं जुलाई रे कोन डेट करो नहीं मासे तो ना मासे रे टाइम 26 जुलाई
well.
This
I
is
feel
matter on 26 जुलाई
interim order may continue to
इंट्रीम ऑर्डर में इंट्रीम बेल टाइम है 28 जाय करछे तो 8 करबा
28 जाय थला the lordships may extend it till 8
गोटे काम करू से प्रथम जो मॉडिफाई करे मॉडिफाई करबानी तळे लिखि देबा कर देल हबो
आगे
देखंतु in view of the above, the interim bail granted by order dated 19/3/2024 is extended till 28th July.
Yes.
In the meantime, it will be taken upon 26th July.
आगे
Yes.
obliged.
Item 43.
43. Yes, Mr. Jana, what is this?
Interim bail.
Interim bail?
Interim bail. Instruction by
What instruction?
Yes, ma'am.
a young boy, 2 ବର୍ଷ 9 ମାସ ରହିଲାଣି
कौन करी?
କିଛି ଦିନ ଯାଉ
No abnormality could be detected. The plan is alter जाई CT scan करी पकेरा.
CT scan करजंती रिपोर्ट भी आनी नाते आमे आनलु नहीं
कौन offense कौन?
302 मालन आर्म्स एक्ट
2 ବର୍ଷ 9 ମାସ ରହିଲାଣି young boy କିଛି police ପାଇଁ
some witness might have been examined in the meantime. 3 eyewitnesses are there.
3 witness man.
Learned counsel, learned state counsel has obtained instructions regarding the illness of the wife of the petitioner, which stop. It is stated that the medical officer of DHH, Raukla, had advised the wife of the petitioner to undergo CT scan of abdomen, which she did on 2/10/2023. It further appears that it further appears from the medical documents that the wife of the petitioner is suffering from some ailment in the abdomen. Considering these above facts, a lenient view is taken. The petition, it is directed that the petitioner be released on interim bail for a period of 2 weeks. 2 weeks. 1 week or something, 2 weeks.
2 weeks thare thana ko jao. So brutal murder malad.
Acha. Condition kariye 1, he shall appear before the ISC of the plant site police station Raukla on every alternate day.
Yes.
And before the trial court on the date fixed date of hearing of the case. In the meantime, yes.
Item 42.
Yes.
Order may be granted in course of the day because 20th June that kala surrender nala NBW issue. Obliged.
Item 44.
May please. 326A along with 307 is the
acid.
Yes. 2 years have 6 months in custody.
I'll call you.
Trial has not yet been started. Not a single witness has been examined. And the person who has allegedly
been in custody for more than 2 years.
No, 3 years ago. 2
years. 2 years. Trial has not commenced as yet. court below is directed to submit a report regarding the status of the trial and as to the reasons for delay. Delay. Release this matter on July
26 July.
26 July. Second week. 12 July. This order will be communicated to the court below forthwith.
Item 45.
May I please? 20B Roman, 20B 2C, 56 kg, 3 persons are involved. In this case, I am appealing for 1 person in this case. Petition in custody,
All are from UP. This person is also in.
Sapon ke 3 ବର୍ଷେ ହେଲା।
ହବନି ସାର୍ ଆଗରୁ ବି ଥରେ ୱିଡ୍ର ହେଇଥିଲା।
ହଁ ୱିଡ୍ର ହେଇଛି ଖାଲି as per instruction ୱିଡ୍ର ହେଇଛି ଏଇଟା ସେକେଣ୍ଡ ଟାଇମ୍
ହବନି। If you want what, I can release this matter from my bench so that you can get your order from any other bench. I will not ଯାଇପାରିବ ମୁଁ release କରିଦେଲେ ପଳେଇବ। Release this matter before any other bench with permission of Hon'Ble the Chief Justice. Yes, so that you may get your relief from some other court, but I will not pass that. I am very clear what I will pass, what I will not pass. Yes.
Item 46. No. May I please? In this case, my lord, lordship has granted bail to all other co-accused persons under annexure 3 series, my lord. I have given all the orders of my lordship, and also lordship has granted this petitioner on 24/11/2023
Shibu Antal
again granted interim bail for a period of 2 months. 24/11/2023 2 मास में देती अब बाकी समस्त को रेगुलर बेल देती
ये कहीं दिया
गला ने आनारे स्पेसिफिक
एवरेज बाय ऑर्डर
आपको 2 मास देले खाली बाकी समस्त को देचंती रेगुलर बेल।
Yes, what is
rejection order shows he is stabbed in the belly, my lord. Rejected whether he stands on similar footing.
No, he doesn't. He doesn't. I had already rejected him. I had granted him 2 months bail. 1 month. 1 month. The petitioner is in custody. Yes.
My lord, the petitioner is in custody since 23/10/2021.
In connection with such and such. It is submitted that all the co-accused persons have in the meantime been released on bail. Stop. Similar submission was made in an earlier bail application filed by the petitioner, which this court did not accept and held that the petitioner stands on a different footing. However, considering the long period of retention of the petitioner in custody, 2 months interim bail was granted to the petitioner. Stop. The petitioner, it is submitted that the petitioner surrendered in time
and moved
without misusing his liberty. It is further submitted that in view of his long incarceration, he may at least be released on interim bail for some time to look after his family members. Yes. Considering the submissions as above and taking note of the conduct of the petitioner in surrendering to custody in time, I am inclined to take lenient view. We will dispose of. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 1 month.
God bless.
Each date of trial appear kariyo na poni link karago. That's why
setik tha wala. Okay.
ଅଲଗା ଲୋକମାନେ abscond କରିବେ।
କେତେ ରହିଲା?
ସେଥିପାଇଁ split off ହେଇଛି। Acquittal ହେଇଗଲା।
ଛଅଟା।
ଅଲଗା କୋ
ଗୋଟେ କରିବ। ପାସ୍ ଆଉଟ୍ ତିନିଟା ଅଛି। ଥାଉ ସେତିକି।
କୋ-ଆକ୍ୟୁଜ୍ ମାନେ ବି acquittal ବି ହେଇଗଲେଣି। Split of trial।
ଯଦି ସ୍ପ୍ଲିଟ୍ ଅଫ୍ ଟ୍ରାଏଲ
ଆଜ୍ଞା
ଅରିଜିନାଲ ଟ୍ରାଏଲ ସେମାନେ ଆକ୍ୱିଟାଲ ହେଇଥିବ।
ଆଜ୍ଞା।
Item 3 ଆଜ୍ଞା ପାସ୍ ଓଭର ହେଇଥିଲା। ସେ ଗୋଟେ ଲଞ୍ଚ period ରହିବିନି, it may be Monday or your lordship is a little bit there is no changing of nomenclature. IN number 18/2024 is there. It has been wrongly TRPC instead of TRPCR, so TRPC errors.
Considering the submissions, the prayer for change of nomenclature is allowed. Office to do the needful. Can ସେମାନେ ନୂଆ ନମ୍ବର ହବ ନା
ଆଜ୍ଞା।
office to do the needful and list the
Obligations.
47 ର modification ଅଛି।
47
ST number ଟା ଭୁଲ ହେଇଯାଇଛି। 59/24/107/22 split of ହେଇକିରି 59।
Item 47 ତ? Considering the submissions, the prayer for modification is allowed. ଦେଇ ଯୋଉଟା ଦେବେ ସେ ଅନୁସାରେ କରିଦେବେ। Subject to conditions as may be fixed by the court below. Including the following conditions of the court.
ପାରା 3 ଟା ଖାଲି ପାରା 3 ଲେଖା ଅଛି।
downloaded copy of that order. And I surrender within the time after just immediately after expiry of the.
What about the witnesses?
Witness, only one witness, one more witness, because the 24 charge sheet witnesses are yet to be examined. As on date, your lordship consider my bail application for interim bail. 11 witnesses were examined. In the meantime, 12 witnesses. Another one witness that has been reflected in the impugned order rejecting my bail application.
I've granted you interim bail in February.
Yes, your lord. In February 1 to 2024, your lordship granted, but I furnished bail bond on 13/5/2024, and on 13/5 I surrendered. On 18/5, my bail application has been again rejected.
Yes, what is it?
Son killed his father.
This is a case of patricide. Son killing father.
Yes, madam.
But here the
ଯାଉ କିଛି ଦିନ ଯାଉଛନ୍ତି ଯାଉ ଏବେ ତ ଆସି ଗୋଟେ ମାସ ହେଲାଣି ଆସି
2020
so what? It's a case of murder.
I have
He may face the capital punishment.
all the material witnesses examined. I have annexed those evidences. Everything is available. No, there is no eyewitness. Even some witnesses saying they're deposing that on the in the night of the previous night, I went with my brother-in-law to my father-in-law's house. In the morning, my father was found dead inside the house.
All right, the petitioner is in custody since
7 to 2021.
7 to 2021. In connection with such and such case, he was granted interim bail for a period of 3 months.
3 months.
As per order passed by this court in BLAPL number 5026 of 2023. It is submitted that the petitioner surrendered to custody in time and there is no allegation of misuse of liberty. It is further submitted that only one more witness since the date of grant of the previous order by this court has been examined. In view of the delay in conclusion of the trial, the petitioner is being harassed and therefore he may at least be released on interim bail in order to look after his family issues. Considering the submissions, therefore interim bail is the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 1 month. No further extension shall be granted. Yes.
Item 49.
One.
ଏଇଟା ନୂଆ ବେଲରେ ଫାଇଲ ହେଇଛି ସେ ପୁରୁଣା କରିଲେ
ଜାଣି 1 month. No, it will become a mockery. You will go on interim bail, you can come back, remain in custody for 1 month, and again make a prayer for interim bail, ଯାଉଥିବ ଆସୁଥିବ ଏମିତି କଣ ହଉଥିବ?
ନା ତାହେଲେ ରହୁ ନହେଲେ ଆଉ କିଛି ଦିନ ଆପଣଙ୍କ ପାଖରେ ଥାଉ
ନା ନା
ଆଉ କିଛି ଦିନ ଥାଉ
ନା ନା
ରେଗୁଲାର ବେଲେ
ବେଲ୍ ଚାନ୍ସ
ଆପଣ ଦେଖୁନାହାନ୍ତି ଏଭିଡେନ୍ସ ଅଛି ମୁଁ
ଥରେ ରିଜେକ୍ଟ କରିଛି ମାନେ ଆଉ ରେଗୁଲାର ବେଲ୍ ହବ ନାହିଁ
ନା
ନା
ରିଜେକ୍ଟ ହେଇନି
ମାନେ ମୁଁ ଦେଇଥାନ୍ତି ମୁଁ ଦେଲି
ଚାର୍ଜସିଟ୍ ଚାର୍ଜସିଟ୍ ପରେ ପରେ ଫାଇଲ କରିଥିଲି ବୋଲି ଟୋଟାଲ ଟ୍ରାଏଲ
ମହାପାତ୍ର ସେତିକି ହବ କେସରେ 6 weeks କରିବି ଆଉ କିଛି ନାହିଁ 1 month ଜାଗାରେ 6 weeks କରିଦେବି 1.5 months ତାଠୁ ଆଉ ଅଧିକ ହବ
ଗଲା ଥର 3 ମାସ ଯାଇଥିଲା ରେଗୁଲାର ଠିକ ଟାଇମରେ ସରେଣ୍ଡର କରି
ନା ହବନି
ଆଉ ଏଥର ଆଉ ଟିକେ
ନା 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 ନା
ଟିକେ ଅଧିକ ଦିନ
no 6 weeks yes.
Item 49.
49. Yes, item 49. None appears. List this matter 1 week after.
Item 50.
Item 50, may I plead your lordship? This is the second application filed by the petitioner seeking anticipatory bail. Your lordship on the earlier occasion had rejected the first bail anticipatory bail application by order dated 10/11/2023, holding that the bail application is not maintainable since there is no allegation against the petitioner in the FIR. Thereafter, your lordship, the police had filed the preliminary charge sheet on 15/12/2023. In the charge sheet, they have sought for further time to continue with the interrogation.
Just a moment. Yes. So how does it improve your case now?
Your lordship, they have sought for further time on the ground that the petitioner, that is, who is the owner of the Oyo Hotel, has not been arrested. In the charge sheet at page 28 of my application, your lordship, may I place that portion of the charge?
Yes.
The accused persons are in judicial custody. The stipulated period of the case is 60 days. As it is a woman-related case, so the stipulated of the case is going to be completed on 16/10/2023. The case is lingering for arrest of another prime accused person, Subba, at Subha's Dali, and the owner of the Oyo Hotel. Petitioner is the owner of the Oyo Hotel, your lordship. Your lordship, the fact is that on the date of the incident, the petitioner was not present in the hotel. The manager of the hotel was present, and he was taken into custody. During investigation, he was taken into custody, and he has been released on bail, your lordship. The bail order is at Annexure 4, your lordship, of the manager.
Annexure 4.
May I place the operative portion of that order at page 30, your lordship, of the application?
Author କେମିତି ଦେଇଛନ୍ତି ଆପଣ? You have given this order half of the order only?
Your lordship, actually, because of the fault of our office, the starting part of the order has been placed at page 31, and the end part is at
All right. This is not the authenticated copy, my lord, I think so.
Huh? This is not an authenticated copy.
Downloaded copy. Na Xerox କରି ଆଣିଛନ୍ତି file.
Order sheet, your lordship, copy has been.
Yes, you have the charge, you have the case diary.
No, my lord, case diary is not there, but that owner of the present petitioner is Saubhagya Ranjan Paik Rai.
He is the owner of the hotel.
Hotel, but here charge sheet lekha hai arrest of another prime accused person Subha alias Subha.
That is a different person. He is a different
person. And the owner of the hotel.
And the owner of the hotel.
Owner of the hotel. But investigation is still open. So his implication.
No, clearly lekha hai na, owner of the hotel भी lekha hai ना.
lekha hai na.
Owner of the hotel, a पर्यंत किसी नथिला बोली, I had passed a judgment, regular judgment पूरा.
My lord.
Holding the is groundless.
I have seen.
Now the charge sheet has been filed.
I will take instruction, my lord.
Yes.
That it has been filed on 15/12/23. Now 7 months has been passed. So I will take
So
instruction.
this order was passed prior to submission of the charge sheet, my previous judgment. Now, since his name figures, name means by designation, it figures in the charge sheet, so he has a legal apprehension.
Apprehension now, in the meantime, 7 months have been passed.
Yes.
So I will take instruction
All right.
to that effect and produce the entire case diary.
The entire case diary be produced for perusal of the court. List this matter on 12 July. No coercive action shall be taken against the petitioner till then. Yes.
Obliged.
Item 51. Item 51, my lords. The anticipatory bail offences under section 3 SC/ST Act is there. Annexure 2 is the order of this honorable court by which the anticipatory bail application of the other accused.
Same order.
Similar order. Annexure. People are named in
Similar order. Yes.
item 52. Same.
Same. Yes.
So item number 6.
The opposite party is the husband, my lord. Filed the case for divorce, my lord. Got notice, the petitioner got notice, which is court of the Hon'Ble.
Well, take notice. Special notice to the opposite party by speed post. Fixing a short returnable date. Requisites be filed by Monday peremptorily. List this matter on 12 July. Then?
So item number 22.
कौन देखे 2024 none appears on repeated calls. List this matter 1 week after. Next week okay? Next week. Yes. चला. No, weekly list.
Weekly list item number 21.
रो खोली पकड़ छोड़ी 21 के ना थे अच्छा हो then
Item number 23.
who's for the other side sir who's for the other side if they do not appear we'll cut out. LCR is there अच्छा let's see.
Just 1 second, sir. Your lawyer,
Substantial question of law is justified in saying that
substantial question of law has been indicated in order number 5 dated 11/12/2006.
Yes.
Whether the learned courts below are justified in saying that the plaintiff has failed to prove title over the suit land when the plaintiff's suit is based on antecedent title and there is no dispute over the title by the defendant, and the defendant has taken a plea of oral sale with alternative plea of adverse position. Second is whether the learned courts below have committed an error of law by putting the onus on the plaintiff to disprove the defendant's case when defendant has taken a plea of oral sale and alternative plea of adverse position contrary to the plea of the plaintiff, and permissive possession, the onus lies on the defendant to establish the plea of oral sale and adverse position. Third ground is whether the learned courts below is justified in not accepting the plea of permissive possession all are same actually, interlinked to each other. The facts are actually very simple. The plaintiff says that the suit land is 4 decimals. Is the ancestral property of the plaintiff, and his father was the recorded owner, Doitari Karna. He got the property in a family partition.
But plaintiff's father is the recorded owner.
Right. And his father. He said that I got the property from my father. So this property belongs to me. Defendant wanted to stay in a portion of the house, of the land, and he was allowed to stay there.
He's an outsider.
Outsider.
But there are 4 defendants.
They are all, I think,
Koiki Sethi, Giran Sethi, Consto Sethi, and Savitri Sethi. Maybe members of the same family, probably. No, all well, Koso.
It is mentioned in the cause title.
Yes.
Sassi Mudali was the original defendant number 1.
Yes.
And having died during pendency of the suit, the defendant 1, 3, and 4 have been substituted.
All right.
They are the legal heirs as it appears. 1986, D1 approached the plaintiff, requested him to stay in a dilapidated house which was existing on the suit land.
Not as a tenant.
No, not as a tenant. So he was allowed to stay there. But on 11/5/96, plaintiff asked him to vacate.
Yes.
Actually, in the same area, actually, as it appears, they are close, known to each other. That is the reason why actually he was allowed to stay there. So he said that you vacate it, otherwise I'll take legal action. A record of right stands in the name of the plaintiff. Defendant says that his father, plaintiff's father, had sold the land in his favor by an oral sale. And he is continuing in possession. Alternatively, since he's in possession, since 1957, I think, he claims to be in possession.
He's claiming adverse possession.
Yes, adverse possession. 57. He failed to prove it. Both the courts below held, defendant could not establish the oral sale. Defendant could not establish adverse possession, but dismissed the suit on the ground plaintiff failed to prove his title.
Okay. The problem is this was not a suit for eviction. This was a suit for title. Suit
Eviction.
for declaration of title.
No, sir, suit for eviction.
No, I think it says that declaration of title on the suit.
Interception, interest and eviction.
Yes.
I think the plaintiff must be there if you can.
Yes, the plate is there. For declaration of title of the plaintiff in respect to the suit land for recovery of possession after demolishing the thatched house standing there over.
Right.
Yes.
So this title, declaration of title, plaintiff has to show some materials to show that he had antecedent title. So there is no dispute over the fact plaintiff's father was the owner.
Yes. Let us see the, I think the written statement will.
But defendant says that he got it from his father.
So his father's title he admits.
I say that fell into my share. Admittedly, my father was the owner. Nobody claims and disputes my title over it.
Yes.
Exhibit 1 has not been reported. Ownership is not disputed. It's a wrong finding by the appellate court itself. The second ground, para 11, relates to plea of adverse possession. It is far too settled that possession follows title. An adverse possession is referred to an adverse title. Actually, an adverse possession means a hostile possession. In denial of the title of the true owner, a party who sets up title by adverse possession has to show affirmatively
is possession of the full statutory period, and presumption and probability cannot be substituted for evidence. But here we confront different situation. The defendants put forth their rival claim of title on the basis of an oral sale accompanied with delivery possession as contemplated under Section 54 of the Act. Since an oral sale of immovable property of value less than 100 rupees can be effected by law by mere delivery possession, the defendants apparently claim lawful title over the suit land. But at the same time, they advance a plea of effect that they have perfected title by virtue of their long-standing possession, which is obviously not sustainable. This is what the defendant have blown hot and cold, the same breath. An adverse possession cannot be referred to a lawful title. More clearly, possession is never considered adverse if it is referred to a lawful title. Acquisition of title by virtue of an oral sale, coupled with delivery possession and perfection of title by adverse possession, as pleaded by the defendant, cannot go hand in hand. The trial court has obviously skipped over this aspect of law, has arrived at a wrong conclusion while deciding issue number 5 in the suit. Such finding of the trial court being derogatory of this established principle of law is unsustainable. Before concluding, I must express that despite vulnerable finding of the trial court in issue number 5, it has rightly decided that plaintiff cannot succeed in the suit in the absence of appropriate evidence of title.
Yes.
That is the appellate court finding. So issue number 5 of the trial court finding, kindly see. Defendant have claimed that they purchased the suit land over 40 years last, date of purchase of the plaintiff's father. They have also filed receipt showing rents, Exhibit C, Seat House Number 2, Padma Karana, as the suit land stands recorded jointly in the name of plaintiff and his brothers. Further, the plaintiff has not taken any measure to vacate the defendant from the suit land as evidence from the plaintiff. All the defendants have filed Exhibit C, Seat 1, but the plaintiff has not given any rebuttal evidence to disbelieve their document. So the conduct of the plaintiff shows that he has not tried to disturb the position of the defendant. In this process, the defendants are possessing the suit land. Hence, they have perfected their title by adverse possession.
I get it.
So that they have not proved adverse possession. Since I did not file an application to evict, therefore they have perfected title by adverse possession. That was held by the appellate court, not correct. This finding is number 5. And title he has referred to Exhibit 1, which is the record of right. In spite of that, he said the plaintiff's denial of legal necessity of his father for selling the land, but did not adduce evidence in this regard, so his evidence is not clear. And plaintiff has no right title interest over the suit land. Here the plaintiff's title is admitted. Plea of adverse possession, hostile animus, and all those things are absent. And they tried to put a case of adverse possession, which they have failed. Therefore, my response is that the appellate court's finding that I have no title, in spite of the Exhibit 1, and my father had title to the property, cannot be accepted to be correct that I do not have the title. So, order of eviction should have been passed and title should have been declared.
Yes.
Defendant has not prayed for adverse possession. He is afraid that the land has been sold by the plaintiff's father to the defendant's father by a oral sale. And you will not see, kindly see the ROR of the ROR of the 58, ROR of 58, Khata number 58. From this Khata, the ROR 24 has been come. This is the Sabik. That is the my lord ROR 24 is half. ROR 58 stands in the name of Padmacharan Karna, Kaliya Karna, Moliya Karna, Pita Doitari Karna. This is a joint family property, my lord, ancestral property. After death of the Doitari Karna, sorry, my lord, prior to the death of the Doitari Karna, the Doitari Karna and his son both have sold the property to the Daulat Muduli on an oral selling.
The question is, both the courts have found, have not believed that oral sale. You have not challenged it?
My lord, the petitioner is staying since 1957.
That is true, all right. You have never challenged, your claim is not, according to you, it is not based on adverse possession, but on that oral sale. Which was disbelieved by both the courts below. That finding is against you. Is it not? Your suit may have been dismissed, but your plea of oral sale has also been disbelieved, including that adverse possession, is it not? Court finding the oral sale equally. Similar dismiss college, plaintiff could not prove his title. It was dismissed on a different ground. But this finding is also against you. And you have not challenged it.
That is so, my lord, but
what is the effect of it?
On oral sale, the delivery of possession to the defendant will lie, my lord, in the delivery of possession of the.
It is your case, I don't say so. But both the courts below have held that they have not believed the plea of oral sale. Have they? Have they believed it? Have they given any finding that yes, there was an oral sale? There is no such finding. Rather, the finding is otherwise, which is against you, and you have not challenged it. The plaintiff's suit may have been dismissed on the ground that he could not establish his title, which he is challenging. We'll find out. But what about you? Not having challenged the finding of the court, whether it is still open to you to raise the plea of oral sale or even adverse possession.
Adverse possession dependent has not been claimed.
Okay, let's leave it. Only oral sale.
Oral sale.
Both the courts below have held. Have they not held that the oral sale could not be proved?
It has not been stated anywhere.
Yes, sir. Mr. Mishra, sir. I think that was a finding. The oral sale was never proved.
Oral sale was never proved.
That is the finding of the court below?
Yes.
If that is the finding, now can you again take up the...
They didn't file any cross appeal.
Yeah, it is not filing. That is what I'm saying. He has not challenged it.
But my lord, his son has been stated that the oral sale has been executed by his
finding kuch bhai ki kon evidence se koi thu alga katha, but what is the ultimate finding? If that finding is against you, then
issue number 5, that finding is oral sale is disbelieved. They say that
adverse possession.
Adverse possession. So if oral sale is disbelieved, it cannot run contrary from the date of oral sale. If a sale is void, supposing I execute a sale deed, sale is invalid. From that day, the adverse possession runs against me. But here there is no sale. If there is no sale, question of adverse possession doesn't arise. Any possession becomes permissive.
No, I was just pointing out that you cannot now raise the plea of oral sale because you have not never challenged.
Trial court against the appellate, they have not filed any cross appeal.
RFA भी also RFA से file करते cross appeal file करनाते, ATP से file करनाते. I don't think Order 41 Rule 33 will come into picture. Will it come into picture here?
No, sir. Here actually it will not come because they have lost their right to claim in appellate stage.
Yes.
They would have done it in appeal. Now we are in second appeal.
Second. Yes, sir.
No.
So you can question their title. You can question, since you are in possession. It is open to you. You may say that you may justify the finding of the court below by saying that yes, they don't have title. How they have not been able to prove their title, because you have heard the senior counsel on the question of title. So you have to say that, because plaintiff is relying on, plaintiff is basing his case on antecedent title. His father was the owner of the property.
My lord.
And this is also your case.
My lord.
Because you say that his father had orally sold the
Orally
property.
sold.
to you.
My lord.
So you're admitting his
My
title.
lord.
Now, in addition to that, he says that that particular suit land fell into his lot in a family partition.
I'm amicable party in the family.
Family partition.
But no family petition deed has been filed, my lord. And they have not sold any family petition.
Yes.
Lord, your lordship, one thing, my lord.
Yes.
Another. One son, Padmacharana Karna. Oh, Daitari Karna. He has said he was giving the rent receipt on behalf of the Daulat Mudli. And he has said, "Ei jami Daulat Mudli mo ବାପାଙ୍କ ଠାରୁ ଖରିଦ କରି ସେହି ଜମି ଉପରେ ଘର ତିଆରି କରି ଆଜିକୁ ପ୍ରାୟ 32 ବର୍ଷ ହେବ ବସବାସ କରି ଆସୁଥିବାରୁ ଏବଂ ବର୍ତ୍ତମାନ ସୁଦ୍ଧା ପଟ୍ଟା ମୋ ବାପାଙ୍କ ନାମରେ ଦରଜ ଥିବା ଖଜଣା ପଇସା ଆମେ ଗ୍ରହଣ କରୁ." That's why, my lord, the petitioner is staying in that plot since long, and he was paying the rent revenue. After the death of the Daulat Mudli and his wife, his daughter and his son-in-law was residing there. In the year 1996, when an ROR was recorded in favor of the plaintiff, he asked the defendant to evict that land, my lord.
So that recording of the plaintiff's name in the ROR was never also challenged by you.
That was, my lord, manipulated. That ROR.
So you should have challenged it. You should have challenged it.
That has been fabricated, my lord.
That's all right. You should have challenged it. It has never been challenged. Unless it is challenged, an ROR as it stands, it has a presumptive value. It has to be rebutted.
But 904 plot is nowhere, my lord, in map. जो ଦେଇଛନ୍ତି ତାଙ୍କ ନକ୍ସା map ରେ 90 plot ନାହିଁ. ଏଟା ସେଇଟା ଦେଖି ଦଉଛି. Exhibit B रे. Nine zero plot is including 716 and 717. 90 plot. 716 717 ଭିତରେ ଅଛି. There is no separate 90 plot. And
what are you saying? That
that 90 plots, the plaintiff is claiming he is the owner of the 904 plot. That is, my lord, absolutely wrong, my lord. False.
There is no plot number.
Yes, my lord. ନକ୍ସାରେ ଦେଇଛି ସେଇଥିରେ 90 plot ନାହିଁ. 716 717 ତାପରେ 718 719 712 714 715.
Suit land ଟା କଣ plot number କେତେ?
904.
अच्छा. So
shoot plot number. He is claiming over the plot numbers.
So
904.
So the ROR, where is that ROR? The कौन exhibit नहीं एथिरे? नहीं.
Exhibit 1 sir.
एथिरे exhibit ही नहीं. देख लो फाइल टा मते रिपोर्ट दलो फिजिकल फाइल टा. ये स्कैनिंग भारी असुविधा होउची. Exhibit. File C.
Record of right ଅଛି sir.
ଏଇଟା
Exhibit 1.
ଏଇଟା ତ
ଆଜ୍ଞା most probably. ଲେଖା ହେଇଛି ଖାତା number 24.
24 କାଳିଆ କର୍ଣ୍ଣ
ରୟତି 908. Plot number.
908 ଘର ବାରି
4 decimal.
ହଁ
This is the suit land as per the suit method. But the plot 716 717
yes
as per the plot index, if you lordship kindly see. এটা দেখিলে
plot index ଟା ଦିଆହେଇଛି
এটা দেখুন
plot index ଟା ଦିଆହେଇଥିଲା exhibit
ଦଉଛି ଏଇଟା but they are trying to raise a question ବୋଲି ମୁଁ ଦେଖଉଛି plot index.
ମାନେ ହାଲ ସବକ ଇଏ
Yes, 908 17 and 18. I claim over 908 suit land. There's no confusion about it. Sir, previous settlement रे चारि भाई का ना record थिला.
yes
हाल रे exclusively in the name of the plaintiff. And elder brother has also given evidence. His elder brother has given evidence. PW2 plaintiffs. So my antecedent title cannot be doubted because my father had the property. Sir, assuming the record of right stands in my name.
yes
Obviously, I derived title from the source of my father.
yes
So how I got it is a different matter altogether. No, my brothers are not disputing.
no 716 717
Sir,
ଏଇଟା ଯୋଉ ଏଠି ଗୋଟେ ଆପଣଙ୍କର ଏକ୍ସିବିଟ୍ ହେଇଛି ଆଇ ଥିଙ୍କ ଏ
sir, A ଟା ସେମାନେ ଫାଇଲ କରୁଛନ୍ତି ପରା. Exhibit A is filed by defendant.
ଆପଣ ଟିକେ ଦେଖନ୍ତୁ ଏଇ ଦିଟା ମାନେ ମାନେ ଏଇ ଯୋଉ ସ୍କାନିଂ ପାଇଁ ଯୋଉ କରାଯାଉଛି ପୁରା ଏପଟ ସେପଟ କରିଦଉଛି ଜାଣି ହଉନି
ଆଜ୍ଞା
ସେଇଟା ମୁଁ ଭେରି ଡିଫିକଲ୍ଟ ଇଟ୍ ସିମ୍ସ ଟୁ ବି ଏ ପ୍ଲଟ୍ ଇଣ୍ଡେକ୍ସ ତା ପର ପେଜରେ ଅଛି 716 717 ଦିସ୍ ଇଜ ଖାତା ନମ୍ବର 24
ଖାତା ନମ୍ବର 24
yes
908 ଅଛି ତ 908 ଘର ବାଡି 4 ଡିସିମିଲ୍
ତା ପରଟା ଦେଖିଲି
ଏଇ 58
Sir, exhibit B.
ସେଟା ହଉଛି exhibit
B.
B. ହଁ B 58 ଖାତା ନମ୍ବର ପ୍ଲଟ ନମ୍ବର 716 717 22 ଡିସିମିଲ୍ ଇଏ ସେପାରେଟ ଠିକ ଅଛି ସାର୍ ଏଇଟା ପାର୍ଟ ଅଫ ଇଟ୍ ହବ ନା 716 717 ପାର୍ଟିସନ ଯୋଉ ସେପାରେଟ ହେଇଯିବ ସାର୍ 4 ଡିସିମିଲ୍ 908 ର ବିଗର ଏରିଆ ଆପଣ ଦେଖନ୍ତୁ ସାର୍ 908 ର ସେ ଖାତା ନମ୍ବର ଆର ଏଇଟା କାଇଁ how many plots are there? Several plots are there. Khata 24 re number of plots are there.
ହଁ ବହୁତ ପ୍ଲଟ୍ ଅଛି 21ଟା ପ୍ଲଟ୍
Right.
ସେ ଯୋଉ 716 ବୋଲି କହିଲେ 716 17
16 17
ହଁ ସେଟା କଣ ଶାବକର
Sabak.
ଶାବକର 716 17 corresponds to ହାଲ 908
No, sir.
right ତ
Yes.
ଏଇଟା ହାଲ
Yes. এটা হচ্ছে সাবকর হচ্ছে বড় প্লট এই 716 700 এটা গোটে হচ্ছে 22 ডেসিমেল গোটে হচ্ছে 45 ডেসিমেল
716 717
Yes.
that was in sabak
Right.
so sabak khata number 58 became hal khata 24
Part of it has become
part of it has been
right.
but the khata becomes 24 acha no
There is no dispute that the property belongs to my father.
yes so what are you submitting
That hall plot number has been recorded on 24/6/1995. They are saying that after partition they obtained this plot, my lord. But they are not showing the any partition deed. Any. Second thing, my lord.
Yes.
He is the plaintiff is admitted that the defendant is staying in that place since long.
Yes.
since long. And saying that part, he is saying when it requires, he asks the dependent to vacate that land.
Yes.
And his brother said that his father has sold this property to the defendant's father.
Yes.
Through a oral sale.
Yes, sir. That is all?
Plot index, I have no plot index with me, my lord. Just to take instruction regarding this.
ये 2005 ର ମସିହା ଆଜି
Let it come on Monday.
ନାଇଁ ନାଇଁ ସବୁବେଳେ ଆପଣ ନୋଟ ଦେବେ
ସେଇଟା ଆଜ୍ଞା ମୋ ପାଖରେ ପ୍ଲଟ ଇଣ୍ଡେକ୍ସ ଟା ପାଉନି
ଆପଣ ନୋଟ ଦେବେ
ସିନିୟର
କିଛି ନାହିଁ ଆପଣ ନୋଟ ଦେବେ
ପ୍ଲଟ ଇଣ୍ଡେକ୍ସ ଟା ବି ଏକ୍ଜିବିଟ୍
ଆପଣ ଯାହା ଦେବା କଥା ନୋଟ ଦେବେ ଆପଣ ୟୁ ନଟ୍ ଚ୍ୟାଲେଞ୍ଜ ଦି ଫାଇଣ୍ଡିଂ ୟୁ ନଟ୍ ଫାଇଲ୍ ଆନ୍ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ଆପିଲ୍ ଆପଣ ଯାହା କହିବା କଥା କହିଲେ ୟେସ୍ ହିୟରିଂ କନକ୍ଲୁଡେଡ୍ ଜଜମେଣ୍ଟ ରିଜର୍ଭ
Evidence is brother has disputed no.
I will go through the evidence. Parties may file the note of submissions and a memo of 21 ଟା କଣ ହେଇଛି so ପାସ୍ over ହେଇଛି
naturally
come next week
ଆଉ ଟିକେ ଦେଖିବା ଦରକାର ହବ
okay please this matter next week
ପ୍ରପର ନ କହିପାରିଲେ
ନାଇଁ ନାଇଁ ଠିକ ସରିଲା sir
I think